during the course of this trial some information about Amanda Colley. She had a dream to one day possibly be an advocate for domestic violence. You heard about Lindy Dobbins, her children, her stepson. You heard she about Lindy Dobbins to get his driver's license. Her children, her stepson, who she inspired. That's who these people were to get his driver's license. A daughter. That's who these people were. A sister, a friend, a daughter, a wife, a sister, and a mother. A friend, a wife. Amanda Colley and Lindy Dobbins were human beings. Amanda Colley and Lindy Dobbins are dead. And they're dead because of one man, the choices that one man made. The selfish choices that he made on August the 27th of 2015. The choices that he made for his own selfish desires, because he couldn't let things go, because he was losing control, and this was the only way that he could regain control. Now, your job is nobody is going to put it lightly, it's going to be a difficult job. Nobody envies the job that you're being asked to do in this particular case. It is a solemn one, but it is an important one. It is a job that requires great courage. So what is your role here today at this phase of the trial? It all starts with the law. Now, it is true, and I'm sure the defense will tell you when they get up here, that there will be no requirement at any point in time, legally, that you return a verdict for the death penalty. However, it is the law, and we talked about this during jury selection, and each of you agreed and took an oath that you would do that. You would consider in this case the death penalty. You also said you would consider life without the possibility of parole. And so I'd like to spend some time with you, talk to you first about your role in this particular case, and then talk to you about the law that applies in this particular case, and sort of how you go about looking at the evidence that the state has presented you in this case, and how to weigh the different pieces of evidence. So what you're going to learn in a few minutes during the jury instructions the judge will give you is that it's now your duty to make a decision as to the appropriate punishment that the defendant should be imposed on the defendant for the crime that he committed, the first-degree murder of Amanda Colley and the first-degree murder of Lindy Dobbins. And there are two possible punishments, as you know, and it's life without the possibility of parole or death. And it is important that you follow the law that are spelled out in the instructions. And I know I don't have to give any big speech about that. Everybody, we talked about that during jury selection. We have full confidence that you will do that. You all said you would do it. You took an oath to do it, and we have no doubt that you will do it. So what is it that what are the questions that you're going to be looking at today as you evaluate the evidence in this particular case? And it essentially is broken down into 4 questions. Number 1, has the state proven at least one aggravating factor beyond a reasonable doubt? Number 2, are the aggravating factors that the state has proven beyond a reasonable doubt, are they sufficient to warrant imposition of the death penalty? That's the second question that you will be considering today. Number 3, do those aggravating factors outweigh the mitigating circumstances that you find to exist in this case? And then lastly, based on those considerations there in these questions, should the death penalty be imposed? Now, one of the things that lawyers, we sometimes get caught up in sort of the verbiage. And we know that you folks, you got summoned, you probably didn't really want to be here, and you got called in, you spent a day or two, however long it was with us. We asked you all kind of questions, some of them very personal questions that made you uncomfortable. And then you got selected, and wasn't exactly a choice. And then you get lawyers standing up in front of you and they're throwing around terms like aggravating circumstances and mitigating circumstances, and you may not have ever heard those terms before. And I think it's important to kind of explain to you what those are and how they factor into the decisions that you'll be making here today. Well, what you need to understand is that when it comes to an aggravating factor, that is the initial standard, the guide that you will use in making a choice between the verdict of either life in prison without the possibility of parole or death. And the judge will tell you an aggravating circumstance is a statutorily enumerated circumstance that increases the gravity of the crime or the harm to the victim. And so it's not just any first-degree murder that qualifies for the death penalty. It has to be a first-degree murder where the circumstances of the case or who the crime was committed against shows that there's an increase in the gravity of the crime or harm to the victim. And of course, as the judge will tell you, it is our burden, the state's our burden to prove each of those aggravating circumstances beyond a reasonable doubt. And that your finding on that has to be unanimous. So what are mitigating circumstances? Those are circumstances that include any aspect of the defendant's character, background, that reasonably indicate that the death penalty should not be imposed in this particular case. And it could be anything. Now, just like it's our burden to prove an aggravating circumstance, it is the defendant's burden to prove a mitigating circumstance. It is their burden. Now, they don't have to prove it beyond a reasonable doubt. They only have to prove it by greater weight of the evidence. But it is their burden to prove. So, the judge will also tell you when it comes to aggravating circumstances and mitigating circumstances, it is not and Ms. Dunn talked about this during opening statement, it is not a mathematical calculation. The state is limited in what aggravating circumstances are out there, and depending on what the facts of the case are, it's limited. It's unlimited in terms of the mitigating circumstances. So it's not, you don't just calculate, okay, there's 4 aggravating circumstances on one side and there's 15 mitigating circumstances on the other side. The 15 win and we go home. It is not a mathematical calculation. It's a weighing process. And I know I looked here behind the judge's bench here, and there's a set of scales. And these scales are an important symbol of justice in our system. And the mitigating and the aggravating circumstances in a case like this, it's a good idea to kind of reflect on that and to kind of have that idea of scales. And then when you talk about aggravating circumstances and mitigating circumstances and the way that you may assign to each of those, oftentimes you will have one circumstance or a factor that weighs much heavier than another. And so as you are going through the aggravating circumstances and the mitigating circumstances, I want you to think about the weight that you would give each one of those factors. You may have one aggravating factor that outweighs all of the mitigating factors, and it could be numerous. And so that's just kind of an example of what it means by weight and how you go through that process. In this particular case, it starts with your conviction in this particular case on counts 1 and 2. Count 1 is the first-degree murder of Amanda Colley, and count 2 was the first-degree murder of Lindy Dobbins. These are the only two counts that this verdict would apply to. So let's talk about the aggravating factors in this particular case. In count 1, the first aggravating factor that you will be considering, and I'm going to talk about the evidence in just a minute, but the first aggravating factor that you will be considering in this particular case is that the defendant in this particular case was previously convicted of another capital felony or another murder, first-degree murder, or a felony involving the use or threat of violence to another person. The second aggravating circumstance that you will be considering today is that the murder in this particular case was committed while the defendant was engaged in the commission of a burglary. Number 3, that the murder was especially heinous, atrocious, and cruel. Number 4, that the murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. And then finally, that the defendant was subject to a domestic violence injunction, and the victim in this case, Amanda Colley, was the person who obtained that injunction. On count 2, the first 4 factors, basically it's essentially the same first 4 factors. The only thing that doesn't apply with regard to this count 2, which is the murder of Lindy Dobbins, is the 5th aggravating factor, and that was the injunction factor. And that only applies to the murder of Amanda Colley. So let's first talk about these first 4 factors. The first 4 factors that apply to both the murder of Amanda Colley and Lindy Dobbins. And what is the evidence that the state has presented to you in this particular case? Well, as I said, the first aggravating factor is that the defendant was previously convicted of another capital felony or a felony involving the use or threat of violence in this particular case. Well, the crime of first-degree murder, in this particular case, we have 2 first-degree murders. We have, when we're considering the murder of Amanda Colley, there's also a second murder of Lindy Dobbins. And the crime of first-degree murder, that is a capital felony. And because it's as Ms. Dunn explained in an opening statement, a conviction that happens contemporaneous with another crime, actually it counts in terms of this aggravating factor. So when you're considering the first-degree murder of Amanda Colley, you can consider the murder of Lindy Dobbins as an aggravating factor. And why is that? Why is that? Why does that aggravate the crime? Well, when you stop and think about it, if he killed one person, it may not necessarily be an aggravating factor. But if you found out that years before he had killed a second person, obviously that would aggravate the first-degree murder. You would consider that. In this particular case, I think a lot of times we might get the impression that because it all happened in the same event, that it all kind of subsumes within each other. But because in this particular case, he not only killed another person, but also he tried to kill 2 other people, those also will count as for this aggravating factor. And as well, the 2 attempted first-degree murders, the attempted first-degree murder of Lamar Dubberly as well as Rachel Dobbins. So you would consider this as one aggravating factor, but because you have 3 different crimes, the murder of Lindy Dobbins as well as the attempted murder of Rachel Hendricks and Lamar Dubberly, you can consider those crimes, those additional crimes, in terms of weight. And I would argue to you that you should give this aggravating factor in this particular case great weight. The second aggravating factor that you will consider in this particular case is that the defendant was engaged in the commission of a burglary. Now, you have already found unanimously this particular aggravating factor. All of you unanimously agreed when you convicted the defendant of count 3, this was the burglary that he committed when he killed Amanda Colley and Lindy Dobbins. How does this aggravate that crime? Well, when you stop and think about it, if a crime happened in public, that's one thing. But a person's house is a place where the law recognizes that that is a place where a person should feel the safest. There's a term called a man's home is his castle. And the reason for that is because out of all the places that we have in our society, your home should be the place where you feel the safest. If you can't feel safe in your home, you can't feel safe anywhere. This was Amanda Colley's home. The defendant had an injunction against him. He was not allowed within 500 feet of the home. And instead of obeying that injunction, the defendant broke into her home and committed this crime. And so in this place where Amanda Colley should have felt the safest, the defendant violated that in order to commit these crimes. The third aggravating factor that you will consider in this particular case is that the murder was heinous, atrocious, and cruel. So what does that mean? What does heinous, atrocious, and cruel mean? Well, the judge is going to read you some instructions on that. He's going to tell you that heinous means extremely wicked or shockingly evil. He's going to tell you that atrocious means outrageously wicked or vile. He's going to tell you that cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. He will tell you that the kind of crime intended to be included, especially heinous, atrocious, and cruel, is one accompanied by additional acts that show the crime was conscienceless, pitiless, and was unnecessarily torturous to Amanda Colley and Lindy Dobbins. So let's talk about that for just a minute. Well, what we have here, we hear on the 911 calls exactly what we're talking about in this particular case.
Nobody was in there. Please stop. Put it down. Put it down. Hello?
And then the call made by Lindy Dobbins.
Ma'am, what's your address? Ma'am? Hello? 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 She said something? No, I didn't. She was screaming bloody murder. That's gunfire? Oh my God. Go ahead. She just said on the other line, somebody said put it down. It was the same area. Okay, is it populating?
So what do we hear in these phone calls as it relates to this aggravating factor? Well, we know from other testimony in this particular case that the defendant shot into the house twice before these murders were committed. We know from testimony that Amanda, Lindy, and Rachel fled and ran to hide in the master bedroom. And then the defendant, who is armed with not one, but two firearms, enters the house and goes into the master bedroom where they are. And at this particular point in time, the defendant is invested. Once he pulls the trigger for the first time, he is invested in this murder, these murders. We know, we hear Amanda Colley on the 911 call pleading with the defendant, pleading with him to put the gun down, pleading with him. And then we hear the defendant shoot her. Then we know from the medical examiner's testimony that Amanda Colley didn't die from those first gunshots. We know that after he shot Amanda Colley, from the evidence, that he then forced entry into the closet by kicking it and then shooting through the closet door. Then we know from the 911 calls, he enters the closet, we hear it, he shoots Amanda, we hear him shoot into the closet, and then we hear him shoot Lindy twice, in the head and in the shoulder. Execution style. Then the defendant, we hear on the 911 call, returns to where Amanda Colley is. We hear Amanda again pleading, no, no, no. Initially it's very soft on the 911 calls. We hear the defendant drop the 9mm. He used the 9mm to shoot into the house. He used the 9mm to initially shoot Amanda Colley. He used the 9mm to shoot and kill Lindy Dobbins. And by the time he got done with all of that, his gun was empty. And when he goes back to Amanda Colley, the gun is empty. He drops it on the floor and pulls out his Smith & Wesson .45 caliber firearm. We hear the defendant call Amanda Colley a fucking whore. We hear Amanda then louder scream, "No, no, no." And then the defendant shoots her 5 times, finishing her off with that .45 caliber handgun. So what does this indicate? As the judge will say, when it comes to heinous, atrocious, and cruel, if there's evidence of complete indifference to suffering, that's heinous, atrocious, and cruel. The defendant going into this home, shooting Amanda, still alive, goes in, shoots Lindy, comes back, Amanda's pleading for her life. He doesn't care. Completely indifferent. He doesn't care. That's heinous, atrocious, and cruel. What else with regard to this aggravating factor? Well, we know from the medical examiner's testimony that for the first 3 or 4 shots, Amanda is likely standing or slightly bending over. You heard that two of those gunshots went through her almost at a horizontal pattern, and Dr. Bulick said that's consistent with someone standing. Another one was she was slightly bending over. Another one was to her hand. We heard evidence in this particular case where the defendant told some of the doctors that he remembered Amanda Colley reaching out for the gun, trying to stop him, and he almost shoots her thumb off. We know that Amanda Colley was shot a total of 9 times. 9 times. Not once, not twice, not 3 times, 9 times. We also know from Dr. Bulick's testimony that several of these gunshot wounds were defensive injuries. We also know from Dr. Bulick's testimony that many of these gunshots were extremely painful. He talked about the ones that went through her ribs, the one that went through her thumb, the one that when she's trying to put her leg up, trying to shield off these bullets, futilely trying to shield them off, one enters her leg below the knee, goes through her knee, and essentially blows her knee apart. Dr. Bulick said this would be extremely painful. We also know that out of all these gunshot wounds, the gunshot that severed her spinal cord which was the most immediately fatal. And it was one of the last, if not the last gunshot. And why is that important? Why did we take the time to kind of go through that with Dr. Bulick? The reason is because as Dr. Bulick said, that all of these guns, it wasn't until this gunshot, all these other gunshot wounds were not immediately lethal. We see from the defensive wounds that Amanda Colley was alive and trying to fight back. We see here the gunshot wounds to her body. 9 times the defendant shot her. Not with 1 firearm, but with 2 firearms. We see defensive wounds to her hand, to her arm, to her legs, to her other hand. What does this show? Amanda Colley was conscious throughout this struggle. Amanda Colley was fighting for her life. And the defendant was not to be deterred. He was on a mission. And that last gunshot wound, the one that severed her spinal cord, and Dr. Bulick said, when that bullet severed her spinal cord, that would have made her a quadriplegic. She would not have been able to move her limbs, her arms, her legs. She wouldn't have been able to stand up. And that same gunshot wound was the one that went through the hand. It went through the hand, then it went through her neck, and then into her spinal cord. So even with the last shot, Amanda Colley had her hands up, fighting for her life, trying to defend herself. Futile as though it may be, from these gunshot wounds that this defendant, those gunshots that he was firing at her. So what else do we see with regard to this aggravating factor? Going back to the beginning of this, he fired into the house twice. Everyone runs and hides out of fear. The defendant is yelling, "Where is he? Where is he? Where is he?" Again, as we said before, the defendant is invested in this plan. He has crossed the Rubicon. As soon as he fired those first gunshots, there was no turning back. He had an injunction against him. He had burglarized the house the night before. He was angry. He was mad. Amanda Colley was seeing someone else. She was moving on with her life. He was losing control. And once he fired the first gunshots into this house, he had crossed the point of no return. He was fully invested in his plan. He was on a mission. Amanda Colley and Lindy Dobbins, they're trapped in this bathroom with no place to run. The defendant, again, he shoots Amanda, and he shoots through the door where Lindy is hiding. You hear Lindy on the 911 call screaming, "Oh my God, oh my God, oh my God." He enters the closet. He shoots Lindy twice in the head area, and then he returns to Amanda while she's pleading with her life and finishes her off. So what does this show? He has no conscience, no pity. If you stop and think about what was going through their minds when they heard the first gunshots outside and they ran to hide, and the defendant comes into the house with these guns. Where is he? Where is he? After hearing the first shots, they know what's about to happen. They are contemplating their own demise at this moment. And that contemplation increases when the defendant shoots Amanda Colley for the first time. You hear, and then Lindy Dobbins, when he shoots into that closet and that bullet hits her in the foot, and she's screaming, "Oh my God, oh my God, oh my God." She knows what's about to happen. He enters that closet. She has nowhere to go. Nowhere to go. And she's cowering in fear behind that dresser as this defendant, with no conscience, no pity whatsoever, walks into that closet, points the gun at her head, and shoots her execution style. That's heinous, atrocious, and cruel. The fourth aggravating factor that applies to both count 1 and count 2, the aggravating factor that you'll be considering today, is that these murders were committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. I want to talk about that last part real quick, without any pretense of moral or legal justification. There is no justification in this particular case. I don't know that anybody's going to argue otherwise. I know that we've heard people make statements, testify about how Amanda Colley would pull him in and then push him back out, and she was cheating on him. And there was no justification for this. There was no justification. The defendant, had a girlfriend, but he didn't want Amanda to move on. There was no justification for what happened here. The judge will tell you when it comes to cold, calculated, and premeditated that cold means that the murder was the product of calm and cool reflection. That calculated means having a careful plan or a prearranged design to commit the murder. And that in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. If you remember, we talked about in jury selection, and in the first phase of this trial, when we talked about premeditation, we talked about how the law does not fix an exact period of time that's required for premeditation. As long as there's sufficient opportunity to form the intent, to reflect on what you've decided to do, have an opportunity to change your mind, and yet you go ahead and do it anyway, that's premeditation. Well, cold, calculated, and premeditated is a little different. It does require a substantial period of reflection in this particular case. But the evidence here shows that the defendant had that opportunity. He had a substantial period of reflection in this particular case. So let's talk about the evidence in this particular case as it relates to this particular aggravating circumstance. Well, we know from the evidence, we heard the text messages, or we saw the text messages, we heard the voicemails, we heard all this evidence that the defendant was angry. He was suspicious that Amanda Colley was seeing someone else. He was keeping tabs on him. He was not allowed at the house, and so he had Mike Dickens kind of looking out for him. Sending him texts, hey, is Amanda's vehicle there? Hey, do you see any other vehicles in the driveway? He had somebody looking out for her. We saw the text messages to Mike Dickens where he's referring to Amanda as a bitch, as a whore, as evil. We know that he had Amanda Colley in his phone. He didn't have Amanda Colley. He didn't have wife. He had her in as bitch. That's the way this defendant thought of Amanda Colley. He was angry. And then we saw the text message that he sent to Mike Dickens that says, now she's going to pay. And that's what we saw in this particular case. Amanda Colley paid, and he made sure of it. We know that Mike Dickens sent the defendant that text of Lamar cutting her grass. And this was fueling this anger. And those suspicions, his suspicions were confirmed the night before. He broke into her house, found those items, the sexual paraphernalia, and he got so angry that he smashed 3 TVs. And then, from that point forward, harassing phone calls, harassing texts to Amanda Colley. This began to build. This was not a sudden thing. This anger and this hatred began to build. And then at 8:51 a.m., you saw the text earlier to the testimony, I believe it was of Detective Colley. He sends a text, call me or I'm going to come find you. Well, at 9:12, he's in court. He has a court appearance. So he goes to court and he enters his plea. And then after he leaves court, between 9:41 and 9:55, he places a phone call to Amanda. And that phone call lasts over 13 minutes. And we know from the defendant's, what he told the doctors, and we found this out during the defense's case in chief, when the doctors got up and they testified about going and evaluating the defendant, what his story was, what he told them. We know from him that he talked to Amanda Colley, and she told him on that phone call that the police were called. And we know from what he told the doctors that she wasn't the one that called the police. She told him that. Which only left one person to have called the police, and that was Lamar. And that made the defendant angry. Because he knew he had an injunction. He wasn't supposed to be there. He knew that he had burglarized the house. At 9:57, we know the defendant is in the area of 95 and 210, and he attempts to call Amanda. At 10 o'clock, he's at the Speedway in front of the neighborhood where he lived in Southampton. At 10:03, he sends a text message to bitch, saying please. And so you could see this constant, he would call her up and he would say angry things to her. And then he would leave a voicemail saying please. And then he left a voicemail on Amanda's phone at 10:07. After this 13-minute phone call. Again, he's on his way back to his house. And then at 10:07, he's at home. You hear somebody saying, get back. And then you hear someone say, you're a moron. After this 13-minute phone call with Amanda Colley where she told him they had called the police, she wasn't the one that did it. He knew it was Lamar. He made a decision. That was the straw that broke the camel's back. It wasn't enough that she was seeing somebody else. It wasn't enough that she was doing things with Lamar that she wouldn't do with him, according to what he said. Now, her significant other had called the police on him because he had broken into Amanda's house. And a decision was made during that phone call to go home and get those guns, the 9mm and the .45. And you hear in this phone call, as he's getting those guns, he butt dials Amanda. You can hear in the background. You hear him say, "Get back." You hear likely his dad saying, "You're a moron," as he's grabbing these guns. We know from the photographs from the crime scene technician, Chris Keegan, who processed the defendant's bedroom, that a 9mm handgun case was found under his bed. That 9mm case matches the serial number for the Ruger 9mm. It was in his bedroom. I know we heard testimony from Rhonda Colley that said those guns were mine. I had them in the car. Well, the evidence shows that that's not true. And she couldn't even, when she was telling the police, trying to describe the gun, she couldn't get it straight. She didn't know what caliber guns they were. She didn't know what color it was. She said they came in a box, but I don't know what the color of the box was. She said that they were put in between the seat, but we know from the defendant's statement to doctors that they were in the trunk, according to him. That box to that 9mm was under his bed. The .45, the box it was in Amanda Colley's house. It wasn't found in Rhonda's bedroom. It wasn't found in her car. They were found in his former house, and the 9mm was found under his bed. The handgun holster was found in the middle of the floor of his bedroom. And then we saw the photographs of the ammunition, the gun case that was scattered on the left side of his bed. And the ammunition, there's the gun case, there's the holster, there's the gun case there with all that ammunition. And these .45 caliber zombie rounds that were found in his bedroom, the ones with the green polymer tip, were the exact same kind and caliber of bullets that were found in Amanda Colley's body and was found in that car that he was arrested in Virginia, as well as these 9mm Luger bullets were found in his bedroom. These match bullets that were found at the crime scene and in Amanda Colley's body. Again, the Ruger 9mm case was found under his bed. The .45 was found at the home on Bellagio. What other evidence is there that this murder was committed in a cold, calculated, and premeditated fashion? Well, we know that at 10:11, we have video from the speedway on 210 that shows the defendant pulling up to the gas pumps. There's a lot of kind of back and forth about why would somebody get a few dollars of gas? Well, you would get a few dollars of gas if your intention, before you go and commit these murders. This was before 10:11. This is about 20 minutes before these murders are committed. He's topping off because he knows what he's about to do. And he knows that when he gets done doing what he's about to do, he's got to get out of Dodge. And he doesn't want to stop for a long time. And so he's going to fill up his tank as full as he can get it. So when he's done committing these murders, he can leave as fast as he can and get as far as he can before he has to stop and get gas. That's why he's topping off. That's the only reason he would do it. We know at 10:14, he's making a purchase at that same speedway, and he's buying some beer, trying to calm his nerves, trying to get a little liquid courage before he's going to do what he's about to do. Between 10:02 and 10:13, the cellular mapping puts his activity on his phone at the home tower that cell phone tower near his neighborhood. What does this indicate? He has a careful plan, a prearranged design. After that 13-minute phone call, he decided what he's going to do. He goes to his home, he gets those guns. He goes to the store, he tops off that gas. He gets a beer to give him some courage to complete his mission. That is cold calculated and premeditated, ladies and gentlemen. So what else is there? We know that when he leaves the gas station, he has to drive to Amanda Colley's house. Now, it's not just up the street. To get from the Southampton neighborhood to Mirabella, it's 15 miles away. And so he has to drive and drive and drive. 15 minutes. And that's assuming he's driving 60 miles an hour, which he likely is not. It's not the interstate. So he's driving 20 minutes. Time to think, time to contemplate, time to consider, time to reflect on what it is that he is about to do. This is not a quick decision and an act. He has to drive 15, 20 minutes from his neighborhood to Amanda Colley's neighborhood to carry out his mission. And then we know at 10:22, he makes a phone call to Bitch. No answer. At this point, he's on the west side of his home tower. 10:23, he sends a text to Amanda, to Amy Mason, his girlfriend, saying, "I love you." At 10:26, another phone call to Bitch. No answer. At this point, he's on the south. He's south of 210 on Highway 16A. He's getting closer to Amanda Colley's house. 10:28, he gets a phone call from Dad. It lasts about 55 seconds. At this point, he's on Highway 16, closer to Mirabella. At 10:31, he gets another phone call from Dad that happens, lasts for about 20 seconds. And at this point, he's at the Mirabella neighborhood tower. Now this lines up almost perfectly with the testimony of Brittany Mano. She was the one, the dog walker, that went to the home across the street from where the defendant lived. And she's there. She shows up around 10:15. She gets the dog, take it for a walk. And as she's taking the dog for a walk, she hears the defendant's dad on the phone. Now this is before the murder. Before the murder, she was very clear about the time. And the time that she testified to matches up with the phone records that show that the defendant was on the phone with his dad. And what is the dad saying? "Son, don't do it. Don't do it." And she hears the person on the other line saying, "I can't take it anymore." The defendant knew what he was going to do. He knew what he was going to do. His father, his own father, is pleading with him, "Son, don't do it." And does he listen? No, he doesn't listen. He doesn't listen to anybody. He doesn't listen to the court when they put an injunction in place. He doesn't listen to his dad pleading with him. He doesn't listen to Amanda when she's pleading for her life. He doesn't listen to anybody. He's on a mission. He's going to do what he's got to do. and he accomplished his mission. Lindy Dobbins, all this talk about Amanda cheating on him, seeing this other guy. What did Lindy do? I mean, we heard text messages that he sent to Mike Dickens. She was interfering every time that Lindy would be talking to Amanda. 30 minutes later, Amanda would say, "I don't love you anymore. I don't feel anything for you anymore." He thought Lindy was interfering. So he had some resentment, some anger toward Lindy as well. Lindy, what did she do other than that? Nothing. She was in the wrong place at the wrong time. She was there to help her friend. She gets a call. She leaves work. She finds out that her friend, that her estranged husband the night before broke into her house, busted TVs, a violent act. And out of concern for her friend, she leaves her job. She goes to Amanda's house to console her, to help her. And they say no good deed goes unpunished. The defendant accomplished his mission. The fifth aggravating factor, this applies to count 1, is that the defendant was subject to a domestic violence injunction, and that the victim, in this case, Amanda Colley, was the person who took out that injunction. And that was something that we had to prove to you during the course of the guilt phase in this particular case. We know that there was, in fact, a domestic violence injunction that's been placed into evidence. And we also know that the defendant was subject to that domestic violence injunction and that Amanda Colley was the person who took it out. It's right there in black and white on the injunction. And so this right here is the fifth aggravating factor. Why is that important? Why is that important? How does it aggravate these murders? Because he knew. He was told. He wasn't just told by his dad or somebody in his family. He was told by a court. Do not have any contact with Amanda. Do not go to her house. That's what makes this crime different than your typical first-degree murder, because he was flaunting the law. He was thumbing his nose at the law. He didn't care. This injunction to him was nothing more than a piece of paper that stood in his way. And I would submit to you, ladies and gentlemen, as you consider all of these aggravating factors, all 5 of them, when you consider their significance in this particular case, heinous, atrocious, and cruel, how he committed these crimes, what was going on in his mind, the cold, the calculated, the premeditated manner in which he committed these crimes, the disregard that he had for the law, for the injunction, for the law that says you can't break into somebody's house and destroy things in their home. You can't break into their house and kill people. When you consider each of these aggravating factors and you're deciding what weight to give them, I submit to you that you should give them great weight. But that doesn't complete your task in this particular case. There have been a number of witnesses, pieces of evidence that you've been asked to consider with regard to mitigating circumstances. Those are things that you can consider in order to conclude that perhaps the defendant, the death penalty is not appropriate in this particular case. And these are things that have been presented to you. And this is the only opportunity that I will get to talk to you. And so I'd like to address some of these that there may be others that I don't know about that the defense may argue. These are some of the ones that I picked up on during the course of this particular trial. And since this is my only opportunity to talk to you, I'd like to address some of these. There were some mitigating circumstances that have been presented with regard to family relationships by the defendant. The defendant, it was argued, or the evidence was presented, that he's a good father to his children, that he's a good son, that he's a good brother, that he's a good uncle. And he comes from a loving and close family. And there's not much that we can argue to dispute that. Most families, not every family, but there's a lot of families that have loving relationships with each other. His family is not any different than really any other. And so the argument is made that to consider these close family relationships and how this would affect them. Well, the law that the judge is going to give you is that you should not base your decision on the fact that you feel sorry for anyone or are angry at anyone. And it's true that his family in this particular case, they're victims too. That's true. But that's nobody's fault but the defendant's. Nobody's fault but his. And the question is, how can a volitional, premeditated act such as these murders by the defendant be mitigated by the fact that his crime negatively impacts his family? It's his fault that he's in the position that he's in today. And also, when you consider that, don't feel like suddenly you can't do your job because you feel that sympathy for them, because that's unfair to you. That's not your burden to bear, because you're not the reason why we're here. The defendant is the reason why we're here. And so it's not fair for you to have to carry that burden. That's a burden that the defendant will have to carry. We heard evidence about his employment history, that he was a good worker, that he was gainfully employed at the time, that he maintained stable employment. And again, you may consider this as a mitigating factor. I don't have much that I can argue to you to dispute that. We heard evidence that it influences his influence on others. He did charitable work through his job, that he was a positive influence on other children, that he volunteered as a baseball and football coach, and that he was a mentor to other employees. We saw a lot of photos in this particular case that showed a lot of this. Photos of his family, photos of his kids. So what is all of this? You may consider this mitigating circumstance. The question is, what weight are you going to give it? As you're considering that, you'll see these photographs and all these show he had a great life. He had a great life. He had a close family. He had good friends, fantastic kids. You saw somebody in these photographs and with that testimony who had chances and opportunities in life. He had every reason in the world, particularly with his kids, every reason in the world to live a law-abiding life. He had sufficient ability not only to get by. We heard one of his co-workers talk about how much money he made. I mean, one of his sisters was talking about how much money he did. He was very successful. He was one of the top earners. He had sufficient ability not only to get by, but to thrive. But the defendant squandered those opportunities. He threw it all away. He threw it all away for this selfish act. So, is that a mitigating circumstance? That's for you to determine. If it is, how much weight are you going to give it? Nobody forced the defendant to get 2 guns from his home and go to Amanda's house. Nobody manipulated him into shooting into the house, breaking in. Nobody twisted his arms to shoot Amanda Colley 9 times. Nobody tricked him into shooting Lindy Dobbins in the head. Those were choices that James Colley made on his own. The opportunities that he had in his life, he threw it all away. Nobody's to blame for this situation other than the defendant himself. We heard testimony that the defendant loves animals. How much weight do you give that in considering the circumstances of this case? How much weight? You heard that the defendant was previously active in race car driving. How did that mitigate against these 2 horrific crimes? That's for you to determine. We heard testimony that from his sister that he was a witness to domestic violence by his mother on his father. Crystal Wright took the stand and said that she and the defendant witnessed her mother, or their mother, take a baseball bat to their father because he was having an affair. And then at Thanksgiving, during that same period of time, when she tried to come over and see the kids, she pulled it, and he told her she couldn't come in. He pulled a knife on her. Well, when you consider her testimony, that sounds terrible. That's terrible. But the problem is that she had previously testified she never witnessed any kind of physical violence between her mother and father. In her deposition, she said nothing. No physical violence between the two of them. But she comes to court and suddenly mom beat Dad with a baseball bat and pulled a knife on him. And so that would be something for you to consider. Has that even been established? Is there any credible evidence that occurred? You have a witness who took the stand and gave inconsistent statements about that incident. The defendant is impulsive. What evidence is there of that? This crime shows the defendant had a very carefully, well thought out plan. Did he draw schematics? No. Did he take days and days and days to plan this crime? No. But it didn't take all of that to carefully plan this crime. You heard evidence that he has a history of drug and chronic alcohol abuse. That he was taking pain medications, antidepressants, and sleep disorder medications at the time of the homicide. That he was diagnosed with depression. That he tried marriage counseling, and that he adjusted well to his incarceration. You'll have to decide: are these mitigating circumstances? Have these been established? If you think they have, you have to decide what weight to give it. And then finally, we heard testimony and argument that the defendant was impaired at the time of the homicides, and that his capacity to appreciate the criminality of his conduct and to conform his conduct to the requirements of the law was substantially impaired. So what did we hear? Well, in terms of these two purported mitigating circumstances, we heard from two defense experts, Dr. Daniel Buffington and Dr. Mark Mills. And what did they tell you? Well, they attributed his behaviors at the time of the crime as not really a volitional act, but he was in a parasomnia state. That he had taken the Ambien, he had taken the Wellbutrin, he had taken the Cymbalta, and they had caused him to be in a parasomnia state. And that because of that, he was reporting these snapshot memories. And they said this was consistent with parasomnia. And therefore, this proves that he was under the influence of these medications at the time. Well, the judge is going to give you instruction about expert witnesses. You don't have to believe everything that expert witnesses tell you. He's going to tell you that they're like all other witnesses, except for one fact, and that is they're allowed to give their opinion. That they're allowed to give an opinion about a subject that you think that they're an expert in. He'll tell you that their opinion is only reliable on a subject about which you believe them to be an expert. And like any other witness, there's no magic dust on an expert witness. There is no special credibility because they have letters behind their name, because they have a doctor in front of their name. They're just like every other witness. You can believe or disbelieve any part of it, or you can disbelieve all of it if you believe that's appropriate. He will tell you when it comes to witness reliability, they're just like every other witness. He's going to tell you that when it comes to witness reliability, when you're considering these aggravating factors and mitigating circumstances, it's up to you to decide which evidence is reliable. He will tell you that you should use your common sense. A lot of times when we see people come in, they're well educated. They have doctorates, they're licensed, they have these certifications. But at the end of the day, we talked about this during jury selection, about going to a doctor and not being quite comfortable with something that they say and needing a second opinion. You go get that second opinion and you make that decision. And each of you said, I believe that I have the ability to listen to what different experts say and make up my own mind, use my own common sense as to what is the right answer. And that applies here in this particular case as well. You use your common sense in deciding which is the best evidence and which evidence should not be relied upon in making your decision in this particular case. You may find some of the evidence not reliable or less reliable than other evidence in the case. You should consider how the witnesses acted as well as what they say. Some of the things that you should consider is, did they have an opportunity to see and know the things about which they testified? The doctors are relying on James Colley. They didn't see him take the medication. They didn't see him that particular day. They're relying on what he told them. Did the witness have some interest in how the case should be decided? This has nothing to do with the money that they made. There was a lot of questions about what do you get paid? $300 an hour, $200. Expert witnesses get paid, regardless of who they're testifying for. They get paid. That's what they do. They deserve to get paid. It has nothing to do with that. It has to do with the defendant. In this particular case, they're testifying about things the defendant told them. So in this essence, the defendant is the witness. Does he have an interest in how the case should be decided? Did the witness's testimony agree with other testimony or evidence in the case? These are things you should consider when determining how reliable is that information. Well, both Dr. Mills and Dr. Buffington admitted that the only evidence that they had, the only source of the information they had, that the defendant actually took these medications and that they actually had the effect that was described came from the defendant himself. They had no other source of that information. It solely came from the defendant himself. And they both admitted that if the defendant lied to them about that would essentially make their opinions in this particular case invalid. So it would adversely affect their opinions because their opinions relied on the truth of that information. So should we trust it? Well, let's ask some questions about that. Well, all the doctors in this particular case evaluated the defendant almost 3 years after the murders. 3 years. Almost 3 years. That's a long time for the defendant to sit and think about what he's going to do, what he's going to tell people, what he's going to tell these doctors. And I know Dr. Buffington, when I asked him these questions, he kind of looked at me kind of sideways like he didn't know why I was asking these questions. He was talking about how he evaluated the defendant personally, talked to him just like he would a client or a patient in an ER or an exam room. But that's not where they evaluated and interviewed the defendant. They were interviewing him in a jail where he's facing very serious charges, the most serious kind of charges. Why is that important? How is that different than a patient in a clinical setting, at a hospital or a doctor's office? Well, the reason is because the reason the defendant is different is because there's a high motivation on his part to fabricate these symptoms. So can you trust that? Well, we heard from Dr. Danzinger. He evaluated the defendant, and he looked at the records. He looked at the information that was provided to him, and he said in the 17 days between when those prescriptions were written and when the murders occurred, there was no ongoing issues. There was no ongoing issues in the days leading up to the homicide. He told you, and again, his opinion was there was no impairment on the defendant's part in this case. That opinion was based on the fact he read a report from a Dr. Harry Kropp, who was a psychologist who evaluated the defendant for competency and insanity. And he told you that Dr. Kropp conducted this evaluation very close in time to when the murders occurred. A lot closer in time to when the rest of the doctors interviewed the defendant. And he said that Dr. Kropp's report indicated that the defendant was actually able to describe the events that happened after court. And that's important because by the time he's in court, he's already allegedly taken the Ambien, the Wellbutrin, the Cymbalta. He said that the defendant was able to describe those events after court. He said that Dr. Kropp said the defendant told him and he was just simply hungover and snapped. He said that Dr. Kropp in his report said that he never said anything in the report about any memory loss, any blackouts, and that he was able to relate facts to his attorney. And that essentially Dr. Danzinger's opinion was that he was making up facts years later. He also reviewed Dr. Mills. Dr. Mills conducted some psychological examinations of the MMPI, the PAI. And those psychological tests, which were hundreds of questions long, indicated that the defendant was actually anger-prone, irritability, low frustration tolerance, thoughts of persecution. These are the things that Dr. Danziger said was driving the defendant on the morning of August the 27th, 2015, not impairment. What else did Dr. Danziger tell you? That he had considered other incidents of violence in this particular case. And one of those was the night before. The doctors say, the night before when he broke into Amanda Colley's home and destroyed her TVs, he wasn't under the influence of the Ambien then. Then there's the deliberate actions by the defendant in this particular case. Dr. Danziger said, when somebody is on Ambien, they may do some complex things, but they're not going to do them very well. They're going to be very foggy. They're going to be incoherent. But here, in this particular case, there are very deliberate actions by the defendant that show clear thinking. We know that he armed himself with not one, but two guns. We know that, again, he tops off his gas tank at the gas station. We know that he buys a beer to calm his nerves. And he drives his car to the neighborhood behind Amanda Colley's house. This is clear thinking. He's trying to conceal his movements. If he was in a fog, if he was sort of an automaton, he would have done those normal, typical things that he would do on a regular basis. He would have just drove up to the front of the house to do this. But no, he didn't do that. He drove to the neighborhood behind Amanda Colley's house. And then we know he flees the area. That shows he knew what he had done and was trying to get out of Dodge. Very deliberate actions in this particular case. Evidence that the defendant's claim is false. Well, we know the defendant is out all night. He gets that call from Daryl the night before. He goes over and they go to a couple of bars, have some drink, do a couple of lines of cocaine. And we know that he has a court appearance at 9 o'clock. And so he comes home around, some people say it was 5 o'clock, and he told Dr. Zenny it was like 6 o'clock. He comes home 5, 6 o'clock after he's broken into his wife's house. He's talked to Mike Dickens, and he takes 2 Ambien to get to sleep. Now he's got court in just a few hours. 3 or 4 hours he's got court. And so he takes 2 Ambien at 5 or 6 o'clock in the morning. It only makes sense that you would actually take the Ambien if you had a full night's sleep available to you. They tell you take the Ambien at night before you go to bed. And Dr. Danziger says, he tells people, don't take it and go to the grocery store. You take it when you're ready to go to sleep. You take it at night. He talked about the half-life, 2 to 3 hours, which means it's basically half as long as it stays in your system. And the reason for that is so you will get a night's sleep. Well, the defendant here, he takes Ambien 2 or 3 hours, 3 or 4 hours, before he has to go to court. That doesn't make any sense whatsoever. And then we heard testimony that the defendant told the doctors that his dad had to aggressively wake him up. And we saw there was text messages and phone calls from the time he leaves Mike Dickens' house at 4:30 in the morning all up until the time that he goes to court. He's on the phone. He's calling. He's texting. He's receiving calls time and time and time again. Now, Dr. Buffington tries to explain it away by saying he's sleep texting. That's perfectly consistent. That doesn't prove anything. In fact, I argue to you the contrary. The reason is because he told the doctors his dad had to aggressively wake him up. I asked Dr. Buffington, well, did he tell you that he was sitting up and his dad wakes him up while he's sleep texting, whatever? No. He's asleep. Or he's not asleep. When we heard testimony, I think it was in the guilt phase from Tammy Folsom, she woke up that morning. What was he doing? He was on the back porch on his phone. He never went to sleep. He never took the Ambien. He was on the phone, calling. He was harassing Amanda, calling her up, telling her, "You're lucky I don't tell the kids about this. You're fucking disgusting. That's what he was doing when he says that he was asleep. You didn't take any Ambien. And then, the most pivotal piece of evidence in this particular case is, we don't have to take anybody's word for it. We had doctor after doctor after doctor get on the stand to convince you that he was impaired. And we got a bunch of fancy words about, what these drugs do and, what kind of effect. We heard all this stuff about nutritional supplements. I don't know what anything that had to do with anything. There wasn't really much of an explanation for that. The Ambien was really sort of the concentration of the testimony. I'm not sure why the other stuff got brought up. But all these doctors got up on the stand to convince you that the defendant was impaired at the time these crimes were committed. But you didn't need to hear from any of these doctors, because you got to see for yourself. The testimony was that he took the Ambien 5 or 6 o'clock in the morning. He goes to court at 9 o'clock. At 9:12, you saw the video, you heard the audio of the defendant in court yourself. You saw a window into that period of time when he was supposed to be under the influence of this Ambien. And what did you see? You saw him taking a plea. You heard the judge going through a plea colloquy to make sure he understood what he was doing. The defendant gave his name. He said where he worked. The judge went to the colloquy. The judge specifically asked him, are you under the influence of any intoxicants? The defendant immediately said no. You hear the judge asking him questions. You hear the defendant responding appropriately. He's not in a fog. He's not confused. On top of that, not only is he answering the judge's questions appropriately, but he volunteers questions. He initiates questions. He asks the judge about early termination of his probation. The judge says, you have batter's intervention permit, that's a condition of your probation. The defendant tells the judge, completely unsolicited, I've already signed up. I've got 24 more classes to go. This is not someone who's confused. And then when the judge says you got $474 in court costs, the defendant responds, I posted a $500 bond. Can I take that money and apply it? That's a pretty sophisticated thinking. This is not someone who's in a daze. This is someone who is completely coherent, clear thinking, and rational. You got to see it with your own eyes and hear it with your own ears. You don't have to take Dr. Buffington's word for it. You don't have to take Dr. Mill's word for it. You don't have to take Dr. Danzinger's word for it. You got to see with your own eyes and hear with your own ears what state the defendant was just an hour before he went to Amanda Colley's home and murdered her and Lenny Dobbins in cold blood. There was no impairment at all. And I submit to you that that has not been established, even by a greater weight of the evidence, and you should not consider that as a mitigating factor. And then we heard testimony from both Judge Tinlin yesterday. We heard from the defendant's own attorney at the time, Kyle Bedrin, earlier in the guilt phase, and both of them said they had absolutely no concerns whatsoever, that they did not think that the defendant was impaired at the time. These were people that actually were in the courtroom with him. Kyle Bedrin was his actual attorney, the person who had had the most contact with him during that period of time. Neither one of them had any concerns and did not think the defendant was impaired. Otherwise, the judge wouldn't have taken the plea. And he said he's seen people before actually have issues with impairment, and he's not taken the plea. There were some questions, well, you had a lot of people in your courtroom, you were a distance away, and the judge like, look, I have 7,000 cases a year. 7,000, I see a lot of people. I can tell. But not in this case. There was no impairment. At the end of this case, at the end of all of this, you have to consider what's involved. The last few days we've heard a lot about the defendant. But what this case is really about or two ladies, two women. Two women who had a future ahead of them. 36, Mary Colley was 36 years old. Lindy Dobbins was 39. Lindy Dobbins had a husband. She had children. She had a stepson. She had parents, siblings, a friend. Amanda Colley had her children, parents, sisters, friends. Many years ahead of them. Their lives were cut short. And they were cut short in the most vile and heinous way. For what? For what? Why? Because he couldn't let go. He may have had a right to be upset, but not like this. Not like this. The defendant was on a mission. Whatever he thought about Amanda Colley, he was not the judge, jury, and executioner of her character. That was not his job. What she did did not deserve a death sentence. What he did in shooting her down the way he did, and shooting Lindy Dobbins and killing her, that does deserve a death sentence. In a few minutes, you're going to go back to the jury room, and you're going to contemplate that verdict in this particular case. And I ask you to deliberate about that. There's 12 of you that will decide that. And it's only going to take one of you to say no. I'm asking each and every one of you, consider the evidence. Consider the aggravating circumstances in this case. Consider the mitigating circumstances. If you do, I'm confident you will find that the aggravating circumstances in this particular case, how the defendant carried out these crimes, will far outweigh whatever mitigating circumstances that you find. And when you find that, I ask you, not 8 of you, 9 of you, 10 of you, or 11 of you, all 12 of you, I ask that you find that in this particular case, this is not a run-of-the-mill first-degree murder case. This is a case where the aggravating circumstances of the case have great weight. What the defendant did in this particular case was horrific. It was not justified. It was unnecessary. And it far outweighs any mitigating circumstances in this particular case. I'm asking all 12 of you, not because I think you should or anybody thinks you should, because that's the right thing to do. And it's going to require courage to do it. The defendant deserves the death penalty. I'm asking all 12 of you, based on the law, based on the evidence in this particular case, that you come back with that verdict, that the defendant gets the death penalty.
Ladies and gentlemen, we're going to go ahead and take a break at this point. Before we do that, I have a couple things to discuss with you. I'm going to have the deputies distribute to you menus. What we'll do is, after you've heard the defense closing argument and my final instructions, when we begin to deliberate, we'll bring in lunch for you. It'll be around the lunch hour, maybe a little later than the lunch hour, but we'll bring in lunch for you so you can have lunch when you are deliberating. So we'll hand out those menus to you as you break. So complete the menus, have them ready to come back when you come back. Again, please do not discuss this case among yourselves or with anybody else during the break. Don't do any research of any type. You still need to hear the defense closing arguments as well as my final instructions on the law that I need to give you before you deliberate your verdicts in this case. So it is precisely 10:30. We'll take 20 minutes. I'll have you come back at 10 minutes to 11, that's 10:50. So at 10:50, be ready to come back and leave your notes here in the courtroom. Yeah. Take a pen with you if you'd like, though, to complete that. That might help. Seated in the courtroom. I'll ask that nobody leave the courtroom when I get word from the deputies that the hallway has been cleared of the jurors, and we'll be in recess at 10:50. At 10:50, Mr. Wood, be ready to go with your closing arguments. proceed in the courtroom. We are ready to proceed, and I'll proceed with the defense closing argument. So we'll proceed when you're ready.
Thank you. All right. We're now, in a very short while, you're going to be asked to make a decision in this case individually. Make your own determination in your verdict on both of these counts of what the appropriate sentence will be for Mr. Colley. First, I want to make sure that, and rightfully so, that we thank you, all of us do, for participating in this very vital function of our society. You've put in so much time in this case, everybody has, and invested certainly your lives, been away from your family and your work, to consider and weigh the evidence that's been before you in what we call the guilt phase, where you were asked to determine at that time, in that period of time, whether or not the state's proven the allegations beyond and to the exclusion of every reasonable doubt. And certainly you've made those findings, and we respect that wholeheartedly. We're here now, obviously, to deal with the sentencing on the homicide counts 1 and 2. And as Mr. Johnson and the judge will very shortly relay to you and lay out for you the law, the jury instructions for you, you're going to go through a process where under the law you have to consider certain things, make certain findings, go through a weighing process, and make your determination in this case. And not only are you going to be given a set of jury instructions on what the law is, and I'm going to highlight some things for you with regard to the jury instructions, but you're going to get a verdict form. And it's going to have a set of questions for you. Not long, yes or no type answers or questions. And we'll show that to you. Another judge will go through that with you. But there'll be a process where you'll see on the verdict form where you'll be allowed to follow the law and render a verdict that will ask you to be, for both counts, life without the possibility of parole. I first want to say, because I think it's extremely important at this point in time, something that just needs to be said. Sometimes it's left unsaid, and I don't want that to happen in this case. We've never argued from the very beginning when Mr. Shoemaker made the opening arguments for the defense in this case, in the guilt phase, that Mr. Colley did not commit the crimes in question. It's not a who done it, it's a how done it. And you've heard evidence in the case, and you've made your decision, and we respect that. We're never going to argue to you, ever, have not, will not, that this is a case where either homicide was justified in any way. This is not a case of self-defense or excusable homicide. Neither Amanda Colley or Lindy Dobbins deserve to die in this case. And Mr. Colley has caused their death, did cause their death, by shooting them. But we're not here to determine whether or not, or make a finding based upon whether or not Amanda or Lindy deserve to die. The law in the state of Florida is if you commit first-degree murder, whether it's premeditated or felony murder, that's against the law. And you know that now you're to consider what the punishment is going to be. So I hope, and I will not in any way say that these are justified. But in the state of Florida, and Mr. Johnson touched upon this, not every first-degree murder case, and we discussed this in jury selection as well too, not every first-degree murder case can the death penalty even be considered. The state has alleged in this case, in what we're going through now, the penalty phase, that they've alleged certain, what we call aggravating circumstances, what the law calls as aggravating circumstances. In the state of Florida, and you'll hear this in the instructions, the state is confined, if they want to argue for the death penalty, to those aggravating circumstances that they convince you, prove to you, occurred beyond a reasonable doubt. Again, this is contrary to the guilt phase. This process that you're about to go through is an individual decision that's made by each one of you, each 12 of you. It's going to go back into the agreement. But in this case, I ask you, and the judge will instruct you. Again, it's not a question of whether somebody deserved to die. It's only the state is limited to the aggravating circumstances that they allege in this case. So let's talk a little bit about the aggravating circumstances that they've alleged, two in particular. Every case is a little bit different. I've been doing this for a long time. And there's a couple of them I want to talk about. One that applies, one aggravating circumstance that applies to both counts in this case, and one that applies in count one with regard to Amanda. You are allowed to consider, and Mr. Johnson certainly has pointed out on behalf of the state, some of the evidence that you've heard in the guilt phase in this case. And you are allowed to consider that, included in the instructions, when you're considering what the appropriate punishment is. Now, there's also obviously evidence that's been put before you in testimony and exhibits in the penalty phase, and you can consider that as well too. But with regard to the cold, calculated, premeditated, aggravated circumstance, you know that in this particular case, we have a situation where you have two people, James Colley Jr. and Amanda Colley, who've been married, I believe, for about 7 years. They have two children together, Trey, whose legal name is James Colley III, and the daughter Avery. And you know that there came a time when they came to live in Marabella on South Bellagio, and were raising their kids together in that house. Unfortunately, their relationship started to deteriorate, particularly in July and August of 2015. And their relationship was not going well. They were having some ups and downs in their relationship. Eventually, Amanda Colley sought and obtained an injunction. But their relationship didn't stop there. They kept seeing each other. Mr. Colley, despite the injunction, would go over to the house. You had testimony at two different occasions from Mike Dickens in the guilt phase and Neil Dickens in the penalty phase, where even the days before the homicides occurred, Mr. Colley is with Amanda Colley and the kids playing in the backyard. The Dickens saw this. And they live, 3 houses down from where the Colleys live. So that's important to consider when you're talking about, and there'll be a number of other aspects too for your consideration when we're talking, I don't know how well you can read that, we're talking about cold, calculated, and premeditated. Because this is, this aggravating circumstance requires more than just premeditation. You've already found him guilty of premeditation. Again, under Florida law, you have to have aggravating factors that you can consider in the gravity of the premeditated murder. What I want to talk to you about is a number of pieces of evidence that deal with what's called heightened premeditation. And then there's also this part here dealing with the definition of cold. Because everything doesn't happen, the events in this case, everything in this case doesn't happen in a vacuum. You've heard a number of different things throughout the course of this very tragic events that happened on August the 27th that show you that this was not a long, the homicides did not occur, were not planned over a long period of time, something like you would have maybe in a contract murder case, murder for hire case, where there's long, lengthy plans in advance for what happened. You have a man married to a woman, and their relationship is going back. You have certainly anger throughout what happened here. There's nothing, I'm never going to say anything that tells you that there were not times where anger was not involved in this case, or rage was involved in this case. You have certainly the events that unfold the morning of August the 26th, or the evening of the 26th, and go into the morning hours of August 27th. Remember, on that everything happens in an arc. What happened is, Rhonda, Mr. Colley's sister, and her husband Dan are in Rome. Mr. Colley is staying at Rhonda's house because he's left the marital home. Amanda stays on South Bellagio. Mr. Colley's mother and father, JT or James Sr., and Judy Colley stay at the house to help with the kids who are there at the house. They're not with Amanda, they're with Mr. Colley. Mr. Colley puts the kids to bed, and then gets a call from his friend Daryl, goes out to a bar, has drinks, some Crown Royal, several drinks. Unfortunately, has some cocaine, 1 or 2 lines of cocaine. Again, he's away from the kids, he's with his friends. At this point, he's not with Amanda. There's nothing going on between him and Amanda as far as communications go. He's off doing his own thing. And it is what it is. There's some aspects about this case where we have to be very honest with you about it. Mr. Colley is a flawed person. He certainly has issues, as we'll talk about more, with alcohol, in particular, alcohol dependency. It's a chronic alcoholic. His sister says that when he drinks, he doesn't stop drinking. How that plays into the morning of August 27th, we don't know, but certainly the history of Mr. Colley is that he drinks, he doesn't stop drinking. But nevertheless, he's out with his friend, doing his thing, and then when he gets done partying with his friend, then he goes over to Amanda's house at that point. And he wants to check on her, she's been sick, she's not there, goes inside, obviously, finds the sex toys. He's upset about the sex toys, finding them. Goes over and vents to his buddy Mike Dickens 3 houses down, shows Mr. Dickens the toys that he had found, the stuff he had found. And Mike tells him, here, have a beer, go home. So he goes home. Of course, he also breaks the TVs. We find out about that. You had pictures inside the house where he broke the TV. So, but does he stay at the house to wait for Amanda to come home? Does he know she lives there? I mean, they were there together just a day or two before. Remember, there was a lice incident that occurred a couple of days before all this happened. They've been together. Mr. Colley was not trying to kill his wife or conducting violent acts upon her in the days leading up to all this. They were seeing one another. They had been seeing another. We had text messages that were filed in court as an exhibit that you could look at. Again, and the judge will tell you all this, every bit of evidence that was submitted and put in evidence in the guilt phase, you go back with the jury room, we'll go back with the jury room, every bit of evidence that's been presented in the penalty phase, which is not as voluminous, that will also go back in the jury room for your consideration and review. But we put in text messages where you see 2 days before, or 3 days before this tragic event, on August the 24th, and I'm not going to read all this for you, but there's text messages going back and forth between Mr. Colley and Amanda about the kids, about Mr. Colley talking about whether if she's having an affair. They talk about Trey going to bed, sending pictures of the kids, or do you have a picture of one of the kids? There's discussion. Remember, it's very important too that you also remember that during this period of time in their relationship, there was a divorce that had been filed in this case. They're going through a divorce, which unfortunately happens with hundreds of thousands of couples in the United States. And so there's raw emotion going on here. And this also can be factored into the cold, calculated, premeditated aggravating circumstance. They talk, there's even a mentioning from Mr. Colley about getting full custody and, you know, about moving on with their life and just back and forth, you know, conversations with two people whose relationship is falling apart. So all of that you can consider when the big picture about what these folks were going through at the time. And then, again, Mr. Colley doesn't stay at the house. He goes home, he has a couple of Ambien. We'll get into the impairment issues here very shortly, but the chronology of events, you know, you went to court, he entered a plea on a case, but remember too that he had a very favorable outcome on the case. Remember, you heard it on the video, he got probation. He got a fine. He was asked the judge, I think the judge said for the third time you can pay off your court costs with the bond that you've already had, cash bond you've already posted. So that kind of, you know, back and forth. But then what happens at the end of the plea is, as Mr. Kyle Bertrand told you, is that Mr. Colley actually hugged him, thanked him, was happy, was in a good mood, you know, at that time. So he leaves court, and then you know that there's more communication between the two of them. You have the text messages and the voicemails, and sure, there's things there that certainly indicate that Mr. Colley is not happy with what's going on. But what also happened is that Mr. Colley is relating to Amanda, let me pay you for the TV. And then, according to some information Mr. Colley brought forward, she mentions about the police being called. And here's where I'll argue, we're not taking this position, but let's assume for a moment that the state's narrative or their argument about what happened next actually happened this way. I'm not taking that position, but let's take their argument for a minute. Where They argue that Mr. Colley had gone back to his house and gathered a couple of guns and ammunition, and then went over to the house. You heard the voicemail, you heard or saw the text messages. Here is, again, if you take what they have to present it here as their argument, this is not a man that indicates he's planning on killing anyone. Here's a man that is upset about what's going on. And then he goes over to the house. Now you also have information too before you to consider about the fact that Rhonda, when she left for Italy, had her guns in the car. She has a concealed weapons permit, but she had the guns in her car away from Mr. Colley. So anyway, he goes over to the house, right? So then Mr. Colley sees a man and shoots at the back sliding glass door. There's nothing indicating, even at that point, I argue to you, heightened premeditation. There's certainly nothing in the definition of cold, calculated, and premeditated about this being cold in the definition of the product of calm and cool reflection. I'm not saying what he did was right. You've already determined what he did was wrong by the attempted murder charges, by the burglary charges, and certainly the first-degree murder charges. So what he did was wrong. But this is an argument the state has to heighten or aggravate the murder charges in their argument for the death penalty. So there's nowhere, I argue to you, in the scenario of events, even if you accept what they presented in the chronology that they presented in its entirety, that there's any long-term plan, calm, cool reflection. Again, I use my example of a situation where you have a contract killing where, hey, I'm going to pay you so much money, you go out and go find this guy and kill him. Nothing like that ever occurred in this case. According to the state's own testimony, Mr. Colley is upset, he's enraged. And that affects his thinking and in judgment. You've had evidence in this case that Mr. Colley is an impulsive person. Certainly he's an impulsive person, but that doesn't aggravate this into a situation where the death penalty is warranted. So that's that one, and so you don't have a heightened premeditation that this aggravating circumstances requires for you to even consider the death penalty. And that's my argument to you on that. Now, with regard to count one, where you have the stalking, the aggravating stalking injunction, aggravating circumstance. Again, that's an aggravating circumstance that talks about where there's no issue that there wasn't an injunction in this case. But what I want to point out to you and discuss with you, because you have to go through a weighing process, each one of you individually, is what does that really mean in this case? Again, nobody's saying what he did was right. Nobody's saying what he did was lawful. You've made that determination in your verdict when you said he was guilty of aggravated stalking. So I'm not here to justify that part of this case. I'm arguing to you that when you weigh the aggravating circumstances in this case, what does it really mean as it applies to this case? Because again, you have two people that's going through a rocky relationship, that Ms. Colley got an injunction, but she has him over repeatedly the week before. He's at the house days, a day before, 2 days before, a week before all this happened. And I'm certainly not arguing to you about the importance of injunctions. They're very important in our society and our law. But these are two people that have been around each other. So when you're not only considering for yourself and determining for yourself, because although we've gone through the guilt phase part where your decision, your consideration is whether or not the charges have been proven beyond a reasonable doubt, even if you reconsider them, which you must do, the aggravating circumstances that 5 are for count 1 and 4 for count 2, you must still determine how much those factors mean in your decision about the life without the possibility of parole or death. And so my argument to you is, what does it really mean in terms of the injunction aggravating factor when you have two people that voluntarily are around each other? And where certainly he did wrong, no question about it, on August 27th, but does what he did on the 27th, when you weigh what happened in the days before, aggravate this case, or count 1 of this case, to the point where the death penalty is justified? And I submit to you, no, that's not the case. As serious as the situation is, as wrong as the situation is that Mr. Colley did to Amanda, does not warrant the death penalty in this case. Now, so that's what I want to bring up as far as the aggravating factors in this particular case. And I'll go through the verdict with you shortly. The other important part of this process is something I call mercy. It's a very important consideration when you're dealing with the death penalty. We as a culture are a merciful people. Our society is a merciful society. I argue to you that the way the process is designed when considering the death penalty in the state of Florida and the instructions that you now or soon will be getting, that the concept of mercy is built into our system for your consideration in a number of different ways. Again, first of all, not every first-degree murder case you can even consider the death penalty. You have to have at least one aggravating circumstance proven beyond a reasonable doubt. And remember, under the law, the existence of an aggravating circumstance, if proven beyond a reasonable doubt, gets the state in the door to talk about the death penalty. But you'll never, ever be required or compelled to render a decision, a verdict of the death penalty in this case under the law in the state of Florida, despite the existence of a aggravating factor or other aggravating factors that are listed by the state. That limitation that our society, that our law imposes on the state in even seeking the death penalty, I argue to you, allows for the concept of mercy to take place, because they're limited as to what they can even argue. We value consideration of the human life, even when we're to punish the accused for the murder that he committed, murders that he committed. The other part of the concept of mercy is when we talk about how to weigh, and how to consider mitigating circumstances. As Mr. Johnson pointed out to you in his closing, and the jury instructions will tell you here shortly, is aggravating circumstances have to be proven beyond and to the exclusion of every reasonable doubt. The factors that Mr. Johnson's outlined. But that's not the case with mitigating circumstances. So our burden is like 51%. Greater weight of the evidence. More likely than not that the mitigation that we presented is proven to you to your satisfaction by the greater weight of the evidence. So I argue to you that built into that concept is, again, our merciful society where we allow for mitigation, which can be limitless. It doesn't just have to be what's outlined in the jury instruction. It can be anything that you thought about, decided, considered in the guilt phase or the penalty phase. And you'll see that in the instructions as well, too. Mitigation is limitless when you're considering the defendant's life, its background, and the circumstances of this case. So again, I argue too that mercy is built into this by making it easier, if you want to use that term, for the defendant to be able to present mitigation circumstances as opposed to the state's burden beyond the exclusion of every reasonable doubt and limiting on what they can argue for. But then the other part, and I'm going to make sure that this is brought up on the occasion. I'm going to see in the scroll down. As a part of the jury instructions, it's going to be read to you. I've highlighted it here. It says, regardless of the results of each juror's individual weighing process, even if you find sufficient aggravators outweigh the mitigators, this weighing process that we talked about, the law neither compels nor requires you to determine that the defendant should be sentenced to death. Neither compels nor requires you to determine that the defendant should be sentenced to death. I argue to you, because this is the law in the state of Florida, that regardless of what the state has presented to you and convinced you exists beyond a reasonable doubt as far as their limited aggravating factors, and regardless of what weighing you ultimately determine for this, the aggravating factors versus the mitigating circumstances, that when you get through and everything is said and done in this case, the law says to you, regardless of all of that, you never, ever have to return a verdict, a sentence of death in this case. And so I argue to, by placing that and instructing you and having that as part of the law, that relates to the concept we talked about, mercy. That despite everything that Mr. Colley has done, has been shown to have done in this case, when everything is said and done, you never have to impose death in this case. And so the law has made it even harder to impose death if the state even sought that. And then the other part is that, and I'll talk about this a little bit more, is when you go into the jury room, how this is going to play out in terms of the process, is your decision on life without the possibility of parole or death is an individual decision. You do not have to be unanimous. You 12 do not have to be unanimous in a decision for life without the possibility of parole. That is an individual one-on-one decision that each of you must determine based on your consideration of the evidence in this case and your best judgment in deciding what is the appropriate sentence in this case. So when you go into the jury room, it is perfectly acceptable for you to consider and weigh the evidence and the circumstances of this case and the mitigation of this case, and you can say for yourself, me, myself, I, based on what I determined to be the case here, based upon my own moral judgment in this case, based on the evidence, I say for myself that life without the possibility of parole is the right call in this case. Me, myself, and I. Unlike the guilt phase, where you know from the instructions of the guilt phase, in order for there to be a lawful verdict, you have to be unanimous. Not so with this phase, with the penalty phase. It's your call individually. And you don't have to agree. Some person may say, no, I think this is what makes it for me. This is why I say life without the possibility of parole is the right call for me. You may have others in your group that say, no, I feel different. That's okay. That's okay. The law allows for that. Mr. Johnson talks with all sincerity about courage in making your decision. I too talk to you about courage in making your decision, because again, you are yourself. You're your own cubicle in terms of how you process this case and make your sentence determination. And you must decide for that. And when you make that determination, if you make the determination that life without the possibility of parole is the correct call for you, I ask you to hang on to that. Keep that with you. Certainly discuss your feelings and your decision and your process of why you come up with that call, why that's the right call for you with your fellow jurors in the jury room, but that's your call to keep. And they may disagree with you, and they should have respect for your opinions as well as your opinions and determinations of theirs. It is all about respect. We respect you for the most serious decision that any person would ever have to make sitting on a jury is life or death. And you're in that situation now. So let's talk about the mitigation in this case. And we called some folks for you to testify about, and hopefully we've kind of given you a full flavor of Mr. Colley as a person. He is to a human being in his life and his career and his family, I submit to you, should be taken in consideration and will be taken in consideration. You had Gail Dickens, who is Mike's wife, who talked in great detail about what a good neighbor Mr. Colley is. That she has her own children that played with Mr. Colley. She was very forthright and honest in talking about the fact that she has a son that has Down syndrome. And what did she tell you about Mr. Colley plays and has a great deal of patience with her own son, with his Down syndrome, and make sure that he's included in the play activities that all the other kids are doing. You have testimony from Ms. Dickens about how good of a father, Mr. Colley is. And how he interacts with his children, takes them fishing and hunting and coaches baseball and football and does everything that a good father would do. And that you can consider in how Mr. Colley is as a person. And again, we're talking about a human being here. Ms. Dickens talked about JR, as we all call him, Mr. Colley, helped Sean with his bike and throwing and catching the ball, playing Frisbee with him. And Ms. Dickens and her husband have known the Colleys for a great number of years. Remember, they moved into Marabella before the Colleys did. And of course, both of them, you heard Mr. Dickens and Ms. Dickens talk about seeing Mr. Colley at the marital residence during the week, the days before all this happened. You had Maria Ober-Isaac, who's the first cousin of Mr. Colley, would see them at family functions, that Easter and Christmas and holidays and Sunday dinners, and talked about Mr. Colley being a great father, again with the fishing and sports activity that he is. She described it as having a sweet spirit, that he's always worked since high school. You've had a number of witnesses that talk about Mr. Colley's great work ethic, that he's had a number of jobs, the last 15 of which have been in the financial mortgage industry. But Mr. Colley's a very hard worker and been able to, certainly obtain a house and earn a living. But he has a great work ethic. She knows him through Chase, working in Chase and City, that she lived with Rhonda and Dan and JR for about 6 months. Again, she talks about him being a good father and coaching. that she talked a great deal about the fact that Mr. Colley's involved in racing. You had other folks that talked about how close Mr. Colley is to his father, who would go on race car activities with him throughout various locations, and how Mr. Colley, worked on the race car, and how much he enjoyed doing that with his father and spent time with his father. You had April Ayala, that is a second cousin to JR, had moved to Florida in '97, been around his kids, talked about how hands-on he is with his kids. She worked at Citibank, had been retired. She worked there 20 years. Talked about JR working in the mortgage department. Talked about Mr. Colley being involved in several charitable events through work, which again shows another side of Mr. Colley, that he took time to work, as Crystal talked about it, volunteering with Habitat for Humanity. That Mr. Colley, April talked about Mr. Colley being very close to his family, his parents, certainly his sisters, and the coaching activity. We had Frederick Cartwright, who's not related to Mr. Colley. He was a young man who had grown up with Mr. Colley and ultimately went to high school with him. He didn't graduate with Mr. Colley because he went to a private school. But what did Mr. Cartwright tell you about Mr. Colley's good behavior, good background? At school, he talked about, remember the one time he talked about when he was being bullied by other kids at the school. They said they were in the 8th grade. And Mr. Colley, JR, stepped in to protect him. There was another instance that Mr. Cartwright talked about where another kid was getting picked on, and JR went and helped that kid out too. At the young age, what are you going to do, 13 or 14 at the time? Mr. Cartwright also talked about the fact that JR is a hard worker. Remember, he talked about that when I think it was his father got sick and needed some help doing the mowing, that without pay, JR stepped in and did mowing. That JR worked and did janitorial work in Daytona for 3 different banks. Worked at Home Depot. So JR's a hard worker, You can take that into consideration. When his father was sick, Mr. Cartwright's father got cancer is when JR stepped in. Talked about Mr. Cartwright again, everybody talks about how good a father Mr. Colley is, and that he's close to his father the most, or his parents equally, I should say. You heard from John Schwinghammer. John is a gentleman that's worked with Mr. Colley at City. That remember, they used to work out together. That's how they got to know each other. On their lunch breaks, they'd work out together. And when that happened, they developed a friendship where his kids started hanging out with JR's kids, and they started doing things as a family. You have a picture and evidence that's on a disc for your review that was both identified, well, actually it's a separate picture that Mr. Schwinghammer identified, and also Crystal identified on the disc, of Mr. Colley being at the beach fishing with the fish in their hands, and all the kids are around him, and they're all smiling, and they enjoy being around JR. That's another certain aspect of JR. You had Mr. Schwinghammer testified again about Mr. Colley doing charitable work, working there, volunteer work there at the workplace. That JR was, again, a coach for flag football. You had Jason Deloach, again, a friend, not a relative, who came forward on his own, took the witness stand, and talked about how good an employee Mr. Colley was, that he was a good producer financially, that he was a mentor to other people in the workplace, that he was a motivated person, very reliable, very trustworthy, did customer service in ways that other people at the office couldn't do. He stepped up and was a great employee. And witnessed him being a father. Again, it was a good father. He talked about that the kids would light up every time, or he would light up every time he was with his kids. That he would help other new employees in their training. Again, this is a human being we're talking about when you're considering whether or not to put him to death or give him life without the possibility of parole. You had John Wright, who is Crystal's husband, who, you know, Crystal and John have had their times being separated, but remember that John, for a period of time, lived with Amanda and JR. That John and Crystal have their own daughter, Savannah, that JR would play with and adored, and likewise. John, too, testified about what a great father JR is with the kids, and kids in the neighborhood adored being around Mr. Colley. He was a good influence on them as well. That he was great with animals, used to play with the dogs. And we had other people talk about how good he is with animals. Crystal talked about that. And that he was a good uncle to Savannah. You had then, just yesterday, trust me, my days are kind of blurring together. We've been here a long time together. Yesterday, you had Crystal Colley, his sister, who told you some honest truths about Mr. Colley as a person. Both some good stuff and then some flawed stuff. Crystal was the one that really pointedly told you Mr. Colley is an alcoholic. She was the one that told you that when he drinks, he can't stop drinking. That he's a binge drinker. That she and others have told Mr. Colley, hey, you need to get help. You know, this is a problem. Unfortunately, Mr. Colley never did get the help. And obviously didn't initiate that himself, but he's an alcoholic, chronic alcoholic. And you had additional backup with Dr. Kuroga talked about that when she testified. But Crystal, too, knows that Mr. Colley and she and her sister Rhonda, the three of them, are very close together. And she talked about the history of Mr. Colley, you know, growing up, that he was born in Illinois in Elgin and then moved as he was a child to Orange Park and went to school in Orange Park. And then when he got older, when JR got older, moved to Volusia County, went to high school there, graduated from Seabreeze in 1999. And then she too talked about his employment history and how good of a worker he is, and that she also too works in the finance industry. Talks about how good of a father he is as well, and gave you a lot of information, you know, about that. She, you know, talked about him, you know, working for humanity, Habitat for Humanity, and doing the boat racing stuff for charity, you know, etc. But she also told you, you know, about the alcohol use. She talked about cocaine use. And that's an example of that he's not a perfect person. And unfortunately, in our society, in our country, we have a lot of folks that are alcoholics. And it would have been great if Mr. Colley had gotten treatment early on, but it didn't happen. She also told you about a couple of times. Well, she knew about his back history and pain medication that he had. But she also told you about the domestic violence that her mom committed when he was a child. Remember, Crystal's older than JR. That, you know, Judy took a baseball bat to his father in their presence when she apparently caught him having an affair on him. that a week later they witnessed Mrs. Colley, Judy Colley, their mother, taking a knife to their father. Now, certainly there was never an arrest in this case on either instance. Crystal told you they reconciled after that. They're still married today. Unfortunately, Mr. Colley, the father, is in very, very bad health. And there's been some testimony about that. Now, the state certainly talked to you about the fact that when cross-examined, she was confronted, Crystal was, about the fact that she denied domestic violence, that she had witnessed that when she was being cross-examined. Keep in mind the circumstances of how this information is unfolding, because, ladies and gentlemen, I hate to state the obvious, but this case has been, you've had media coverage in this case. You've had reporters in here. This is in live, in color, in front of a ton of people, talking about what she experienced and saw in court. She said it was not easy. And she was embarrassed that other people, knew about it. So it's extremely difficult in circumstances to talk about this sort of stuff. Nobody does. But despite all of that, the parents reconciled, and then, as you already know, the family unit is very close together. So these circumstances that I've outlined for you, the judge will read to you in here very shortly the mitigating circumstances. And again, these only have to be proven by the greater weight of the evidence. Now, we also had testimony, expert testimony from Michelle Quiroga, who is a neuropsychologist. And what she was did testify about, is what we talked about in number 11, mitigating circumstances. Mr. Colley has a history of drug and chronic alcohol abuse. Certainly that was part of her evaluation, and that she determined and gave the opinion that Mr. Colley suffered from alcohol dependence. And also to that 19 and 20, that Mr. Colley was taking pain, antidepressant, and sleep disorder medication at the time of the homicides. And certainly number 20, which has not been refuted, that Mr. Colley has previously been diagnosed with depression. You've got, even on that score, you've got testimony from all the doctors, actually, that Mr. Colley, in August of 2015, was taking depressive medication. First the Wellbutrin, and then that was discontinued, and then Cymbalta was prescribed for him on August the 10th of 2015. So Mr. Colley suffered from depression. Then he suffers certainly depression, while the big diagnosis was depression since he's been in jail. Facing these charges. And that's a mental health condition that certainly you can take in consideration with regard to Mr. Colley. Now, I call her Michelle, Dr. Quiroga also talked about the fact that, let me get you the number on the mitigation on this list, that he was number 23. James Terry Colley Jr. was adjusted well to his incarceration since being arrested in this case. Dr. Quiroga testified that since Mr. Colley's been in jail, that he's done well in the jail. Remember, she talked about that in terms of him taking care of himself. She told you that he's taken become a certified paralegal, taking a paralegal course while in jail. So you have that information for you. And why is that part important? Why does 23 have significance in this case? Because when we're talking about the appropriate sentence in this case, the appropriate sentence in this case is life without the possibility of parole. Here is a man if that sentence is imposed in this case, is going to spend the rest of his life in prison. He's demonstrated just in the 3 years that he's been here, and certainly nobody's making light of the fact he's incarcerated, and deservedly so. He killed 2 people. He's incarcerated. But he's going to be able to do okay in prison because he's done okay in the jail here. Not saying that's a great thing, nobody is, but you can take his behavior and how he's adjusted to jail when you consider the appropriate sentence of life without the possibility of parole. Now, certainly there's been testimony about impairment. That's one of the list on the list of mitigating circumstances. And again, this is a list that's actually these are the ones that are listed, but you can consider anything else in this case, and that's number 24, which is what we would call the catch-all mitigator, which is existence of anything, any other factors regarding Mr. Colley's character, background in life, or circumstances of the offense that would mitigate against the imposition of the death penalty. That could be things I haven't brought up that are not on this list, that nobody's talked about, but it's on your mind. You, hey, this, I caught this. Maybe the fact that he did well in high school, he had good grades, he was on the honor roll. Maybe that's something you want to think about. Maybe there's something else about what's been presented to you that's not on this list, but it's important to you. And there may be things, and this is in the instructions too, there may be things that one of you thinks about, hey, this is really important for me. This is why I want to do life in prison. I think that's appropriate. And somebody else may say, well, you know, this other thing is really important to me too. That's okay. You don't all have to agree on the same mitigators. And it could be something else that we haven't talked about. Lawyers, being lawyers, we kind of get a little narrowly focused sometimes on what we think is important, but that doesn't mean that that's not important to you. And so keep that in mind. But let's talk about a couple of the factors that are on that list, which we seem like we spend a lot of time for. We had expert testimony that sometimes takes a while to get through and digest and all that, which is the impairment. And again, mitigating circumstances, think of the scales that are right before the judge, just a tip, just a 51%. There's been no dispute in the evidence that in August of 2015, Mr. Colley wasn't prescribing anything. And that previously, before August the 10th, he was on Wellbutrin, and then he had the change of medication to Cymbalta, another antidepressant. Dr. Buffington talked to you about how it takes a while for medication to really take its full effect. It takes a few weeks for that to happen, and then through doctor's orders, for whatever reason, Mr. Colley has switched to another medication. All that has an effect on the body. But Dr. Buffington, the pharmacologist, talked about the neurotransmitters and how that can affect the mind. But on the morning of this tragic set of events, Mr. Colley takes the Ambien. You had Dr. Mills and Dr. Buffington, Dr. Mills being the psychiatrist, talk about how this parasomnia can affect from Ambien, which is an known adverse side effect, how people can do intricate things, how people can even sleep drive and do other types of activities and then not remember what they were doing. I think this was even talked about by a couple of jurors that had that experience during jury selection. But we have a situation here where Mr. Colley takes medication in the stupidest way. I mean, let's be honest. You got to get up in a couple hours and then you're going to take the Ambien. But what happened before that? Take that in consideration. He's out partying with his friend Daryl. They were out until 2 or 3 o'clock in the morning, gets home about 5. And he's had some cocaine that he's done before. Now he's wired, he's up, he's got to get some sleep, he's got court. It's important, obviously, to attend court. So he's got to get something to take him down. And then he's woken up after a couple of 2-3 hours by his dad, and the Ambien hasn't even really peaked at that point in time. And we've had testimony, expert testimony from Dr. Mills and Dr. Buffington, how they even explain, you know, he can text, he can do things even when he's being impaired by the ambient. Wasn't taking any other, took his other pain medication, according to other information that you had that morning, and goes to court, and then the other events unfold, as you know now, and has been talked about extensively. So you had two experts, one's a psychiatrist and one is an experienced pharmacologist. The pharmacologist talked to you extensively about adverse side effects of Ambien, that is well documented, that is known to literature that all experts have in the field. And you can consider and weigh their testimony and their expertise. And I ask you to consider that in whether or not Mr. Colley was either impaired or substantially impaired at the time of the homicides. And that's for your consideration. We know certainly he was upset, he was enraged, but movements can also be affected by Ambien. All right, so let's put a couple of things up for you. You know now that, and we've talked about this, that your decision is an individual decision, and that you have every right to hang on to your decision once you've made that decision in this case. We ask you to do that when you come to the conclusion that life without the possibility of parole is the correct decision, the correct sentence in this case. What does that, what are we really talking about here? Again, we talked about this, you do not have to be unanimous in your decision about life without the possibility of parole being the right sentence in this case. We've talked about mercy, that's inherent. This is, I pulled that out separately to remind you that you do not have to, no jury ever has to determine or is required to render a death sentence in this case. Sometimes, and this was discussed a little bit in jury selection, I want to make sure we're all on the same page about it. We'll talk about your feeling, when you talked about your feelings about the death penalty, and the discussion about following law, and I tried to make sure in jury selection that you understood that life without the possibility of parole is a legal sentence. It is one of the options that is available to you at this time. The law says that that's an appropriate sentence. And hopefully all of you understand now that if you determine for yourself that life without the possibility of parole is your decision, you should know and always know that that's a legal sentence. And that is one of your options in this case. But let's really talk about and get into what we're talking about here. You know, after everything is said and done, we're really not talking about how Mr. Colley will live after today. We're really talking about under what circumstances Mr. Colley will die. And I know that's a weighty decision for you to talk about. And certainly, I don't know what you're going to talk about in the jury room. Obviously, we don't go back there with you. But some of you may be thinking along the lines of the mitigation and what we presented to you, and there's a great deal of that. I argue to you that the weight of the aggravating circumstances, either by themselves individually or in total, outweigh the aggravation in this case if you go through that actual weighing process. But if you impose a life without the possibility of parole sentence for these counts, he will leave prison in a pine box. That's what that sentence guarantees. He's going to die in prison. That's what we're talking about. And that's a lawful sentence. So I want to talk to you about punishment, because that may be something that may be on your mind when you go into the jury room, as you're considering that lawfulness and appropriateness of that sentence. You know, it's noon today. If Mr. Colley were in prison at this very moment, tomorrow at noon is going to look the same for him as it will for every other noon, for every day, every week, every month that he is on this earth. To the point that someday, for whatever reason, however it comes about, God takes him from this earth as he's serving his life sentence, because he'll never be able to get out of prison on either account when that's the sentence. That's what we're talking about for Mr. Colley, for what he's done in this case. And that is a legal sentence, and that's a sentence that you can impose. So if you're thinking about punishment, this is the punishment that Mr. Colley, under the law, deserves. If that is the thing that is most on your mind, is the punishment that he deserves. If that's on your mind, that's the sentence for you. Life without parole. He dies in prison. When, how, every day for the rest of his life is going to look the same in prison. Every day for the rest of his life, he's going to have to deal with what he's done in this case to two people that he killed. And what happened leading up to that? Those tragic, serious consequences for what he's done. Life without parole does that in this case, ladies and gentlemen. And that's a decision that he will have to live with the rest of his life, how long that is, in prison. And that's the appropriate sentence, I argue to you in this case. That's the right thing to do. And I ask each and every one of you to think about this case individually and say, hey, this is the call for me. I need as many of you as we can. If it's unanimous that life without parole is the right call for you, great. 10, 9, 8, doesn't matter to us. However many possibly that you decide. But know whether it's a merciful decision or a punishment decision, life without parole is what does it in this case for both counts. Now, how you do that is on the verdict form. And the judge is going to go over this with you, so I'm not going to go over it in great detail. And there's going to be two for you because we're dealing with two counts. But built into the law and the process, you're going to go and make some determinations about the aggravating circumstances and whether or not any of them have been established. And then you'll make a finding as to mitigating circumstances, and certainly there have been a plethora of mitigation presented in this case for you to check yes. And then D, you're talking about a weighing process, whether or not the aggravating circumstances outweigh the mitigation circumstances. I argue to you no. But there's several off-ramps that are in this decision. Even if you were to even go to the first one, Section A, if you didn't find that there were any aggravating circumstances that have been proven beyond reasonable doubt, then you stop there and your decision in life that Mr. Colley will be sentenced to life without the possibility of parole. But then you go on from there and make other decisions. And when you go through the weighing process, but then you come to the very end, after everything is said and done, in Section E. And after you've made your weighing process for yourself, again, individually, you're asked to decide whether or not, or asked to determine whether you unanimously found that he should be sentenced to death. And then it's a yes or no, and under that you're told that if your vote to death is less than unanimous, the court will impose life without the possibility of parole. And here is I submit to you, your final out on that from a legal perspective, the legal instructions. Is going back to this instruction that tells you, when you get to E, that regardless of the results of your individual weighing process, even if you find that the sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to determine that the defendant should be sentenced to death. That, ladies and gentlemen, is what we're asking you to do in this case. 1, 2, however many of you individually decide that's the right call, make that call for yourself, hang on to that call for yourself, go into the jury room and tell the other jurors why you feel that way, but hang on to your life decision. And render a sentence in this case that's both lawful and punishment that Mr. Colley deserves in this case under the law, for life without the possibility of parole. Thank you.
Folks, we've been going for a little while, and the next thing that's going to happen in this case is I'm going to instruct you on the law. It's going to take maybe 20, 30 minutes or so. So why don't we take a short comfort break? I'll have you stay up here so we don't have to worry about moving back and forth. So we'll take 10 minutes. I'll check with the deputies to make sure you're ready at that point. I don't want anybody to rush. But let me caution you, please don't discuss the case among yourselves. That opportunity will come soon enough. And don't do any research during the break. Right? So we'll have you stay up here. When you come back, you'll have a set of jury instructions in your chair, and then I'll instruct you on the law. I'll leave your notes and all materials in your chair. Thank you, folks. Everybody else remain. the jury in. Everybody ready?
Yes, sir.
Bring the jury in. Make sure they're ready. Welcome back, everybody. Welcome to see the courtroom. Everybody get settled in. Okay. Folks, in your shares, you have the jury instructions. I'm about to instruct you on the laws you need to follow to render your verdicts in this portion of the case. And you'll have a copy of those jury instructions to take back with you when you deliberate your verdict in this case. Members of the jury, you have heard all the evidence and the argument of counsel. It is now your duty to make a decision as to the appropriate sentence that should be imposed upon the defendant for the crime of first-degree murder. There are two possible punishments: life imprisonment without the possibility of parole, or death. In making your decision, you must first unanimously determine whether the aggravating factors alleged by the state have been proven beyond a reasonable doubt. An aggravating factor is a circumstance that increases the gravity of a crime or the harm to a victim. No facts other than proven aggravating factors may be considered in support of a death sentence. The aggravating factors alleged by the state as to count one are: 1. James Terry Colley Jr. was previously convicted of another capital felony or a felony involving the use or threat of violence to another person. The crime of first-degree murder is a capital felony. The crime of attempted first-degree murder is a felony involving the use or threat of violence to another person. 2. The first-degree murder was committed while James Terry Colley Jr. was engaged in the commission of a burglary. 3. The first-degree murder was especially heinous, atrocious, or cruel. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily torturous to Amanda Colley. 4. The first-degree murder was committed in a cold, calculated, and premeditated murder without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. 5. The first-degree murder was committed by a person subject to a domestic violence injunction issued by a Florida judge, and the victim of the first-degree murder was the person who obtained the injunction. The aggravating factors alleged by the state as to count 2 are: 1. James Terry Colley Jr. was previously convicted of another capital felony or a felony involving the use or threat of violence to another person. The crime of first-degree murder is a capital felony. The crime of attempted first-degree murder is a felony involving the use or threat of violence to another person. 2. The first-degree murder was committed while James Terry Colley Jr. was engaged in the commission of a burglary. 3. The first-degree murder was especially heinous, atrocious, or cruel. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily tortious to Lindy Dobbins. 4. The first-degree murder was committed in a cold, calculated, and premeditated murder without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. You have heard evidence about the impact of this murder on the family, friends, and community of Amanda Colley and Lindy Dobbins. This evidence was presented to show the victims' uniqueness as individuals and the resultant loss by Amanda Colley and Lindy Dobbins' death. However, you may not consider this evidence as an aggravating factor. As explained before the presentation of evidence, the state has the burden to prove an aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt, and you must not consider it in providing a verdict. A reasonable doubt as to the evidence, a reasonable doubt as to the existence of an aggravating factor may arise from the evidence, a conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find the aggravating factor does exist. A finding that an aggravating factor exists must be unanimous. That is, all of you must agree that each presented aggravating factor exists. You will be provided a form to make this finding as to each alleged aggravating factor, and you should indicate whether or not you find each aggravating factor has been proven beyond a reasonable doubt. If you do not unanimously find that at least one aggravating factor was proven by the state beyond a reasonable doubt, then the defendant is not eligible for the death penalty, and your verdict must be for a sentence of life imprisonment without the possibility of parole. At such point, your deliberations are complete. If, however, you unanimously find that one or more aggravating factors have been proven beyond a reasonable doubt, then the defendant is eligible for the death penalty, and you must make additional findings to determine whether the appropriate sentence to be imposed is life imprisonment without the possibility of parole or death. If you do unanimously find the existence of at least one aggravating factor, and that aggravating factors are sufficient to impose a sentence of death, the next step in the process is for you to determine whether any mitigating circumstances exist. A mitigating circumstance is anything that supports a sentence of life imprisonment without the possibility of parole, and can be anything which might indicate that the death penalty is not appropriate. It is not limited to the facts surrounding the crime. A mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may reasonably indicate that the death penalty is not an appropriate sentence in this case. It is the defendant's burden to prove that one or more mitigating circumstances exist. Mitigating circumstances do not need to be proven beyond a reasonable doubt. Instead, the defendant need only establish a mitigating circumstance by the greater weight of the evidence, which means evidence that more likely than not tends to establish the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you must consider it established and give that evidence such weight as you determine it should receive in reaching your verdict about the appropriate sentence to be imposed. Any juror persuaded as to the existence of a mitigating circumstance must consider it in this case. Among the mitigating circumstances you may consider are the following. James Terry Colley Jr. was a good father to his children. James Terry Colley Jr. was a good worker. James Terry Colley Jr. was a good son. James Terry Colley Jr. was a good brother. James Terry Colley Jr. was gainfully employed at the time of his arrest. James Terry Colley Jr. has maintained stable employment. James Terry Colley Jr. was a mentor to other fellow employees. James Terry Colley did various charitable works through his employment. James Terry Colley Jr. was a great uncle. James Terry Colley Jr. witnessed domestic violence by his mother on his father as a child. James Terry Colley Jr. has a history of drug and chronic alcohol abuse. James Terry Colley is impulsive. James Terry Colley Jr. loves animals. James Terry Colley Jr. was a positive influence on other children in the neighborhood. James Terry Colley Jr. volunteered as a baseball coach. James Terry Colley Jr. volunteered as a football coach. James Terry Colley Jr. was previously active in race car driving. James Terry Colley Jr. tried to go through marriage counseling with his wife. James Terry Colley Jr. was taking pain, antidepressant, and sleep disorder medications at the time of the homicides. James Terry Colley Jr. had previously been diagnosed with depression. James Terry Colley Jr. was impaired at the time of the homicides. The capacity of James Terry Colley Jr. to appreciate the criminality of his conduct or to conform his conduct to the requirements of law was substantially impaired. James Terry Colley has adjusted well to his incarceration since being arrested in this case. And the existence of any other factors in James Terry Colley Jr.'s character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death penalty. Your decision regarding the appropriate sentence should be based upon proven aggravating factors and established mitigating circumstances that have been presented to you during these proceedings. The next step in the process is for each of you to determine whether the aggravating factors that you have unanimously found to exist outweigh the mitigating circumstances that you have individually found to exist. The process of weighing aggravating factors and mitigating circumstances is not a mechanical or mathematical process. In other words, you should not merely total the number of aggravating factors and compare the number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or values by different jurors. Therefore, In your decision-making process, each individual juror must decide what weight is to be given to a particular factor or circumstance. Regardless of the results of each juror's individual weighing process, even if you find that the sufficient aggravating factors outweigh the mitigators, the law neither compels nor requires you to determine that the defendant should be sentenced to death. Once each juror has weighed the proven factors, he or she must determine the appropriate punishment for the defendant. The jury's decision regarding the appropriate sentence must be unanimous if death is to be imposed. To repeat what I just said, if your verdict is that the defendant should be sentenced to death, your finding that each aggravating factor exists must be unanimous. Your finding that the aggravating factors are sufficient to impose death must be unanimous. Your finding that the aggravating factors found to exist outweigh the established mitigating circumstances must be unanimous. And your decision to impose a sentence of death must be unanimous. You will be provided a form to reflect your findings and decision regarding the appropriate sentence. If your vote on the appropriate sentence is less than unanimous, the defendant will be sentenced to life in prison without the possibility of parole. The fact that the jury can't make its decision on a single ballot should not influence you to act hastily or without due regard for the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that a human life is at stake, and bring your best judgment to bear in reaching your verdict. When considering aggravating factors and mitigating circumstances, it is up to you to decide which evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in making your decision as to what evidence should be imposed. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted, as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Did the witness's testimony agree with the other testimony and other evidence in the case? Had the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give an opinion. However, an expert's opinion is only reliable when given on a subject about which you believe that person to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusions about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. These are some general rules that apply to your discussions. You must follow these rules in order to make a lawful decision. You must follow the law as it is set out in these instructions. If you fail to follow the law, your decisions will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. Your decision must be based only upon the evidence that you have heard from the testimony of the witnesses, as seen in the form of exhibits and evidence, and these instructions. Your decisions must not be based upon the fact that you feel sorry for anyone or are angry at anyone.
Remember, the lawyers are not on trial. Your feelings about them should not influence your decisions. Your decisions should not be influenced by feelings of prejudice or racial or ethnic bias. Your decisions must be based on the evidence and the law contained in these instructions. In just a few moments, you will be taken to the jury room by the bailiff. When you've reached a decision in conformity with these instructions, the appropriate forms should be signed and dated by your foreperson. Now let me go over those forms with you. Again, you'll have them in paper. There are two separate verdict forms, one for count 1 and one for count 2. I'm going to go over those with you. They're pretty self-explanatory. We should be coming up on the screen in a moment. There we go. All right, the top of the verdict form identifies the case and case number as the state of Florida versus James Terry Colley Jr. The first form I'll go over with you is the verdict as to the sentence on count 1. It's broken into sections, and I'll explain that to you in just a moment. It starts off, we the jury find as follows as to James Terry Colley Jr. in this case. The first section is section A. What you'll see is after each section there's instructions that tell you what to do, whether you go to the next section or not. The first section, section A, is aggravating factors as to count 1. It starts off as follows. We, the jury, unanimously find that the state established beyond a reasonable doubt the existence of the following aggravating factors. 1, James Terry Colley Jr. was previously convicted of another capital felony or a felony involving the use or threat of violence to a person. The option is yes or no, and whatever your unanimous verdict is on that, you would check that box. The second question in section A, the first-degree murder was committed while James Terry Colley Jr. was engaged in the commission of a burglary. The choices are yes or no. Whatever your unanimous verdict is on that, you would check the appropriate box. The third choice in section A, the first-degree murder was especially heinous, atrocious, or cruel. The choices are yes or no. Whatever your unanimous verdict is on that, you would check the appropriate box. The fourth choice is the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Again, your choices are yes or no. Whatever your unanimous verdict is on that question, you would check the appropriate box. And then the fifth question in section A is the first-degree murder was committed by a person subject to a domestic violence injunction issued by a Florida judge, and the victim of the first-degree murder was the person who obtained the injunction. Your choices are yes or no, and again, whatever your unanimous verdict is, you would check the appropriate box. Once you're done answering those 5 questions, these are the instructions at the bottom of section A. If you answer yes to at least one of the aggravating factors listed above, please proceed to section B. If you answered no to every aggravating factor listed above, do not proceed to section B. The defendant, James Terry Colley Jr., is not eligible for the death penalty and will be sentenced to life in prison without the possibility of parole. You would be done at that point, sign and date the verdict. If you are going on to section B, I'll cover for you the questions in section B. So one question. Section B is entitled Sufficiency of the Aggravating Factors as to count 1. The question is as follows. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt in section A, we the jury unanimously find that the aggravating factors are sufficient to warrant a possible sentence of death. The questions are yes or no, those are your choices, and whatever your unanimous verdict is, you would check the appropriate box. If you're answering question B, the instructions then right below that are as follows. If you answered yes to section B, please proceed to question C. If you answered no to section B, do not proceed to section C. The defendant, James Terry Colley Jr., will be sentenced to life in prison without the possibility of parole. You would be done at that point and sign and date the verdict. We cover section C with you now. If you're answering section C, it is entitled Mitigating Circumstances. This is the question. One or more individual jurors find that one or more mitigating circumstance was established by the greater weight of the evidence. The choices are yes or no, and whatever your verdict is, you would check the appropriate box. Then the instruction begins or is on the next page. If you are answering Section C and you've completed Section C, the instruction states, please proceed to Section D regardless of your findings in Section C. So let me cover Section D with you. Section D is entitled Eligibility for the Death Penalty for Count 1. The question is as follows. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt in Section A outweigh the mitigating circumstances established in Section C above as to Count 1, first-degree murder. The choice is yes or no. Whatever your unanimous verdict is, you would check the appropriate box if you're answering in Section D. And then the instructions provide as follows. If you answered yes to Section D, please proceed to Section E. If you answered no to Section D, do not proceed. James Terry Colley Jr. will be sentenced to life in prison without the possibility of parole. You would be done at that point and sign and date your verdict form. If you are continuing on to Section E, this is the question. It's entitled Jury Verdict as to the Death Penalty. This is the question. Having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt in Section A, that the aggravating factors are sufficient to warrant a sentence of death in Section B, and that the aggravating factors outweigh the mitigating circumstances in Section D. We, the jury, unanimously find that James Terry Colley should be sentenced to death, yes or no. If you're answering that question, you would check the appropriate box depending on your verdict. And as it states at the bottom, if your vote to impose death is less than unanimous, the trial court shall impose a sentence of life without the possibility of parole. That concludes the verdict form for Count 1. The foreperson would then sign and date the verdict. Let me now cover with you the verdict form for Count 2. Very similar. It starts off, we, the jury, find as follows as to James Terry Colley in this case. The first section is aggravating factors as to Count 2. It reads as follows. We, the jury, unanimously find that the state established beyond a reasonable doubt the existence of the following aggravating factors. There are 4 here. Number 1, James Terry Colley Jr. was previously convicted of another capital felony or a felony involving the use or threat of violence to a person. Whatever your the choices are yes or no, whatever your verdict is, you would check the appropriate box. The second question is the first-degree murder was committed while James Terry Colley Jr. was engaged in the commission of a burglary. The questions or the options are yes or no. Whatever your verdict is, you would check the appropriate box. The third option, or third question, excuse me, the first-degree murder was especially heinous, atrocious, or cruel. The options are yes or no. You would check the appropriate box to reflect your verdict. And the fourth question, the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. And choices are yes or no. Whatever your verdict is, you would check the appropriate box. The instruction below that is if you answered yes to at least one of the aggravating factors listed above, please proceed to Section B. If you answered no to every aggravating factor listed above, do not proceed to Section B. The defendant, James Terry Colley Jr., is not eligible for the death penalty and will be sentenced to life in prison without the possibility of parole. And that would be the conclusion if it was no to every box, every one of the 4 questions. You would be done at that point and sign and date the verdict form. If you answered yes to at least one, you would move on to Section B as the instructions state. This is the question for Section B. It's entitled Sufficiency of the Aggravating Factors as to Count 2. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt in Section A. We, the jury, unanimously find that the aggravating factors are sufficient to warrant a possible sentence of death. The options are yes or no. Whatever your verdict is, you would check the appropriate box. The instructions below that in Section B provide as follows. If you answered yes to Section B, please proceed to Section C. If you answer no to Section B, do not proceed to Section C. The defendant, James Terry Colley Jr., will be sentenced to life in prison without the possibility of parole, and you would be done at that point. If you're moving on to Section C, this is the question. It's entitled Mitigating Circumstances. One or more individual jurors find that one or more mitigating circumstance was established by a greater weight of the evidence. The options are yes or no. Whatever the verdict is, you would check the appropriate box, and then as the instruction states at the bottom, please proceed to Section D regardless of your findings in Section C. Cover Section D with you as it pertains to Count 2. It is entitled Eligibility for the Death Penalty for Count 2. The question is as follows. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt in Section A outweigh the mitigating circumstances established in Section C above. As to Count 1, it should be Count 2. That should say Count 2, by the way, just a correction on that. For first-degree murder, the options are yes or no. Whatever your verdict is, you would check the box if you're answering that question. And then as the instruction states below, if you answered yes to Section D, please proceed to Section E. If you answered no to Section D, do not proceed. James Terry Colley Jr. will be sentenced to life in prison without the possibility of parole, and you will be done at that point. Sign, date the verdict form. I'll go on to Section E. If you're answering Section E, this is the question. It's entitled Jury Verdict as to Death Penalty. This is the question. Having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt in Section A, that the aggravating factors are sufficient to warrant a sentence of death in Section B, and that the aggravating factors outweigh the mitigating circumstances in Section D, we, the jury, unanimously find that James Terry Colley Jr. should be sentenced to death. The options are yes or no. Whatever your unanimous verdict will be, you would check the appropriate box. As it states right below that, if your vote to impose death is less than unanimous, the court shall impose a sentence of life without the possibility of parole. That concludes the verdict form for Count 2. And the foreperson would sign and date the verdict form and return it to the courtroom. I have a few final instructions for you before I conclude and you have an opportunity to deliberate. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case, and you must not talk about this case in person or through the telephone, writing, or electronic communications, such as a blog, Twitter, email, text message, or any other means. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of these types of electronic devices into the jury room. So in just a few moments, I'll talk to you about that, but we'll have you leave them here if you still have them with you at this point. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any instruction I have given you in this case, you must tell me by giving a note to the bailiff. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent to the jury room with you when you begin to deliberate. I cannot participate in your deliberations in any way. Please disregard anything I may have said or done that made you think I preferred one decision over another. If you need to communicate with me, send a note through the bailiff signed by the foreperson. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. In closing, let me remind you that it's important that you follow the law spelled out in these instructions. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules that we all share. Let me cover a couple of things before you retire and deliberate in this case. First of all, our two alternate jurors, Ms. Sexton and Mr. Legacy. As you can see, the other 12 jurors are healthy, thankfully, and are able to deliberate. Many times that doesn't happen, and the alternates do have to slide it, but you will not be able to deliberate a verdict in this portion of the case. And I'll have some instructions for you in just a few moments about all of that, but I'm going to have you all stay behind. Do you have anything downstairs that you need to gather up?
Yes.
You do? Okay. So before you go, we'll have one of the deputies take you down there so you can get whatever you need. And then, of course, get whatever bags or anything that you brought in today. And for everybody else, does anybody still have a phone or electronic device? Okay. If you can leave those on your seats, they'll be secured while you're deliberating, and they'll be right back in your seats when you come back. So if you have a phone, tablet, laptop, or any other type of electronic device, you cannot take that back with you when you deliberate, so please leave that on your seats. For everybody else other than Mr. Legacy and Ms. Sexton, I'm now going to have you follow Mr. Gray. He'll take you to the jury room. Hopefully lunch is down there. If it's not down there, it'll be there shortly. Take your notes with you, take your instructions with you, and we'll get the evidence and verdict forms to you just in just a few moments. With that, you may retire to deliberate your verdict. Thank you, folks. Made that correction to that one typo, so if you want to look at that, that's fine. Y'all can be seated. Ms. Sexton and Mr. Legacy, you are now officially done with your jury duty. You're probably disappointed that you don't get a chance to deliberate on this, but as you saw, everybody else was healthy and able to deliberate. That doesn't happen all the time, so often the alternates play a very valuable role. As I've been telling you for the last couple of weeks, don't discuss this case with anybody. I'm not going to tell you that anymore, because now you're free to discuss this case with anybody that you want. You're likewise free to not discuss the case with anybody. So if that's your choice, just tell somebody you don't want to talk about it. It's entirely up to you. I do want to thank you on behalf of everybody here in the courtroom for your service. You will get a letter from me in the mail. It's not another jury summons. You are exempt for a year on jury duty, so if you do get another summons in a year, let us know and we'll get you out of that. You should get an exemption for a lifetime after sitting for a couple of weeks, but it's only a year. But that letter thanks you for your service, and it also asks you if there's anything that you think we can do to improve the jury experience. And there's a phone number and an email address, so if there is anything, please let us know. We do take those very seriously. We do need your buttons, so if you leave your buttons in your seat together with your notes, your instructions, or anything else, you're more than welcome to stay behind to see what your fellow jurors are going to do. I have no idea how long they're going to deliberate. I can never predict those things. You are likewise free to go if you want to go. We can call you with the verdict if you want us to, but you also probably can turn on the news and find out what it's going to be, because you can see that they're here. But with that, you are free to go. Thank you very much for your jury service. And one of our deputies walk Ms. Sexton down to the lounge so she can get her materials, and then also we need to get whatever bags you all know. Y'all can be seated. Are there any Are there any exceptions, objections, exceptions or objections to the jury instructions as read, other than those that were previously raised during our multiple charge conferences?
No other objections other than what's been previously stated, Judge.
Okay. Let me ask you all this while you're here. And y'all can sit down. If the jury's verdict as to an appropriate sentence in this is life imprisonment, there are mandatory sentences for counts 1 and 2. Counts 3 through 7 are not mandatory sentences. There are discretionary sentences in there. The defendant would be entitled to a pre-sentence investigation to address all the counts. Somewhat academic, I guess, because of counts 1 and 2. Would you all want to proceed to sentencing today, or would you want to put that off to another date?
Can we discuss that a little bit?
Absolutely.
Before we make that call?
Okay, and with regards to if there is a verdict by the jury finding death to be the appropriate sentence for either of the counts, my plan would be to schedule a Spencer hearing in approximately 45 days, somewhere in that neighborhood. After the Spencer hearing, I would want sentencing memorandums from both sides, probably within 10 days of that Spencer hearing, and then from that point forward, I'd schedule a sentencing hearing down the line. So look at your calendars also while you're talking to see what might be a problem for you in the next 45 days in the event the jury goes in that direction. Okay.
Thank you.
We'll be in recess, don't stray far.